All right, good afternoon, everyone. Today is March 1st, 2022. We're here for a meeting of the Montgomery County Community Choice Pilot Program, Maryland Public Service Commission, PC54 work group. Everyone who's here, if you would please type your name in the chat box so that roll can be taken, and also put your organization, please. By way of announcement, see, I muted the incoming and outgoing tone because we still have people joining. By way of announcement, we're going to be attempting to move from Cisco WebEx to Zoom. So you can expect a new invitation for the next meeting. And hopefully we'll be able to get this working on Zoom. I don't have any experience sharing documents on Zoom, but we'll all learn together. Today, we're talking about the enrollment straw man that was circulated by staff. And what we're going to do is, let's see, on February 17th, staff circulated enrollment straw man 3.0. And then there were comments from the parties. I'm going to go through each of the parties and see if there's anything that you want to say. And if anyone has any answers to any of the questions that are asked, and then we'll go to staff who circulated a recent 3.1 edition today, and staff can explain where we are, and hopefully that makes sense to everyone. Francis, I see you have your hand raised.
I don't mean to. I'm just trying to get it down. Sorry.
I just took it off. No worries.
Okay.
Oh,
Okay.
it's back up again. Okay, so
is it down? Okay, thank you.
No worries. After staff submitted the February 17th 3.0 enrollment straw man, there was a question from Montgomery County from Ms. Brennan. And let me see. Ms. Brennan asked, regarding post and startup enrollment, staff presented several options for how new customers would be enrolled in the CCA, and the county is interested in hearing from the utilities about the pros and cons of each approach, including any cost ramifications. Do any of the utilities want to go ahead and answer those questions, or does Montgomery County want to elaborate any further?
Good afternoon. Lisa Brennan on behalf of Montgomery County. Yeah, I mean, that's basically, staff had put in a few alternatives, and it wasn't clear from the discussion at the last meeting. It sounded like those were coming from staff as possibles versus utilities as preferreds. So, we just wanted to follow up on that and see, were these things that were preferred by the utilities? If so, why? What are the cost ramifications of doing the different alternatives? That would be very helpful. And if I could also say, based on some other comments, it may be really helpful for staff to go over the dates and the requirements for notices that is in the statute, just so we're all starting on the same page for this discussion, because I think there were lots of questions about what notices were, this is about what notices are being sent when. So that may be helpful for folks.
Okay, staff, did you see this? I mean, utilities, did you see this email from Ms. Brennan on the 23rd, and do you have responses that you can provide?
This is Taylor Beckham from PHI. We did see Ms. Brennan's email. I think what we did was try to respond to the proposals within our comments. So I think we should just go through discussing our comments, and where Montgomery County has any issue or questions or issues, just voice them then as we go through the responses to the comments. That'd be my thought.
Montgomery County, are you okay with that?
Sure, absolutely.
Okay. The next comment was from Ms. McGilvray. She put forth some questions. Ms. McGilvray, do you want to address your questions, or are you similarly okay with going through the latest straw man proposed by staff and with asking your questions at that time?
Yes, I thank you, Judge Grace. I think we could go through it as we go through the straw man. I just wanted to be clear about kind of the different situations and categories where notification of customers would be triggered and how that would be done, and what are any time requirements associated with that.
Okay.
So we can go through it. We can raise those questions as we go through the straw person.
Okay. And then we heard from PHI and then AOBA. Mr. Carey, are you okay with starting with staff and asking your questions at that time?
Yeah, Fran and I can do that.
So then we'll just go ahead and turn to staff. I did see Mr. Vanderhayden, I did see this morning that there was a question from who was it? Mr. Trout, about whether or not your latest version was responsive. So I'm just gonna go ahead and throw the floor to you.
All right. Thank you, Judge Grace. I guess I will probably need to begin to share the document, but to answer the question, I think Peter Wilson, our attorney, responded back to Mr. Trout, indicating that we have incorporated everyone's comments in this revised 3.1 document that we sent last night, and we're going to walk through all that and try to capture it. As part of that discussion, some of what we captured ended up in comments. So I know that there were a number of edits that folks made directly into it. In some cases, we had to move things to different spots, and so we did not, just drop things in the same way it was recommended. But we have gone through all the responses, and we believe we sort of captured, the sentiment there. And to the extent that it's a decision point, we're trying to raise that, maybe the comments to do that. So let me try and see if I can share the correct screen here and get this set up. Can everybody see the top of the document here?
Yes.
Okay, good. So I'm going to walk through this. I'm going to also be following along with a printed out version of this. So if folks have that, it's also sort of handy. All right. So if there's, as there's questions going through, either I can't actually see hands going up because of the way the software displays the remaining folks. I have a little tiny square up in the far corner of my other monitor, but I will try to, if you have a question, raise your hand, and Judge Grace, if you notice that, could you let me know, or perhaps folks can just chime in. I think we can probably handle it that way.
Absolutely.
And then when Mr. Hoppick and I went through this yesterday, probably took us close to 2 hours to go through all of it. So I have the expectation we will probably need till at least one, or till like maybe 3 or 3:30. Hopefully optimistically to get through all of this, but we'll handle the questions as we go. I think before I start talking about this document, we had the enrollment and the billing straw man. I think last time we sort of locked down the billing straw man. So if there are questions that are going to relate to that, we would probably need to put them back at the end of the call. But I think as of last week, we had the assumption everybody was more or less okay with it. And then I'm anticipating that our next move after getting the enrollment straw man squared away is to try to look to see which regulations within the retail choice, customer protection in particular, and maybe some of the others, we will need to start taking a look at. So just thinking about where we're going next, that's probably our next set of topics. And then also thinking about how folks have been asking some questions about dates and timing. I think the process and the documentation around the application that the CCA will make with the commission is also probably in our fairly near future. So just food for thought there, but we will, I guess, expect for the next call, we'll probably be hopefully locking this up and squaring most of that away, and then developing some work in between the calls to try to set our agendas for the meetings that I think we'll be having probably around March, I guess 15th, and then the works after that. All right. So let me just start here. The first, and I have a copy of all of the comments. So if folks want to call out something that they put in their comments that we didn't get a chance to, if you don't think we addressed it correctly, feel free to chime in and state that, because not all of the comments were something that we ended up making a direct change to. So the first, just starting up here at the beginning, this is where we're talking about kind of the enrollment that's going to occur at the start of the program. So that's when we're going to have sort of a mass volume switch that's going to occur over about a month. And I think the first comment, this was probably something that came out of the utilities comments, I believe. This comment here where it says, there was a question in the utilities comments that said, hey, is this is very early. I think maybe it's the retail suppliers raised this as well, that November 1 of 23 is extremely early for when we'd be sending that first notice out. And it was going to create lots of customer confusion because the actual switching would not be occurring for almost 12 months after that. So
Phil, can I just make one comment?
Yes, please.
Francis, just to be clear, in the point above, it says, in order to send the customer notification, utilities would send the CCA to a list of all eligible accounts, including all accounts that are served, plus retail choice. I just want to make sure when we say all eligible accounts, we're meaning non-demand commercial, small customers, and residential customers. It's not being sent to all retail classes, correct?
Yeah, the only, I think we'll use the instructions in the legislation that says small commercial and residential.
Okay, that's great. Thank you.
When I was using eligible, I mean, perhaps we should make a good definition of that somewhere, but the law is pretty clear about which customers. And I think we haven't said what we're going to define as small commercial, but generally folks look at what is a type 1 SOS customer, which is 25 kW and down. So I don't think we've said that. Actually, it's probably a good point for you to bring that up, but maybe
Well, that's actually in the statute too.
it says type 1 SOS.
Statute, yeah.
No, it goes by the 25.
Okay, perfect.
It says less than 25 kW.
Okay, that's how they're defining small commercial. Good. Well, then that probably whoever put that together knows how we would define it. Okay, Fran, did I answer your question?
Yes, you did.
Okay, great. All right, so my comment here is if we want to talk about when this notice is going to go out and that it would happen later, I think we are pointing out that the law talks about a 60-day notice prior to initiating the CCA. So the date of November 1 of 23 is about 60 days before the end of the year. And the earliest that the CCA can make application, I believe, is either the end of 23 or like the first day of 24. So for the folks who had concerns about that being too early, is there another way to comply with that 60-day requirement that gets it closer without simultaneously delaying the application of the CCA to a point that's later in the year, which has its own additional complications, in particular with SOS and the SOS bid process planning. So I think that was raised either by the utilities or the retail suppliers on that. I think maybe, does anybody want to sort of comment on that? I think, yeah, it was the supplier's response. The initials are GL1 in the comment.
Hi, Phil. Can you hear me?
I can hear you. Hi, Leah.
Okay. Yeah, no, I think we did flag it, and I think you'll recall even in the PowerPoint deck that we have presented, I guess at our last meeting, we had attempted to sort of flow out this timeline that sort of showed the sequencing of events. And I think you may recall in there that we sort of backed it up from October 1 of 24, when I think the county has indicated that would sort of be the first date when they would begin serving customers. So we started with that as sort of the real kind of end point here. I mean, it's the beginning point of the CCA, but sort of the date we're all working towards to make sure the CCA can get off the ground and get moving. So we kind of built out this timeline starting with that as the date. And when you look at the noticing prior to the thing actually starting, I think you have to hit these 60-day and 30-day notices as well. And so our timeline also had on it the statutory language. So we saw this dichotomy that was in there where you're kind of dealing with two different timelines. And I think that was one thing that, I do think the group needs to figure this out and discuss it, because I think setting out the notices in 23, fully a year before the county is actually going to go ahead and move forward, I think it does cause confusion. So I guess, my question is there a way to read this? I think the statute is sort of assuming that the county would start in 23 with actually enrolling customers and getting the CC off the ground. With the decision made to let's accommodate SOS transition and make sure we're not disrupting all those wholesale contracts, it does sort of raise this question of, does that make sense? You know what I mean? So I don't know what the legal answer is. I know, there are lawyers on this phone that can speak more directly to those kinds of questions, but it did seem to us, when you're really playing this out, that the purpose of the notices is to let customers know this thing is coming close enough to the time it's coming so that they remember, and you're also not repeating the exercise. I think that was the other issue we raised. If you do these notices in 23, you're going to have to do them again in 24 prior to customers actually getting switched, right? Because you've got to do the opt-out notice that soon too. So you're really putting the county in the position of paying twice for all of this noticing, and that didn't really make a lot of sense to us either. So I guess, in my mind at least, the more important dates to hit are those 24 dates prior to October 1, because that's when really the thing will actually get started, and presumably the county will actually file its application with the commission leading up to those dates, so that you're kind of meeting that timeline. It's just sort of a year later. So I guess those are my basic thoughts on that. I don't know if that makes sense or not, but I think we also try to think of it from a customer experience perspective, and I think it seems wiser to me to reduce confusion, reduce drive calls, because these will drive calls to everyone's call centers here. It's not going to only be the county that are going to be impacted by customers calling. It's also going to be suppliers who have customers that are on our supply that are going to get these notices. It's going to be the utilities. So it's real, and it's going to be the commission too, frankly. Everybody's going to get calls when these notices go out. That's just what happens.
So if I could, then I think you're sort of highlighting, and it's an excellent point. We will have to do a very good job of customer education for this. I think when we reviewed this, and I'm very interested in hearing everyone else's opinion, we're looking at the legal notice requirement as being something that has to happen 60 days beforehand. And there's language in there that says gives written notice of the aggregation plan. Written sort of implies maybe it's actual snail mail, but possibly email can qualify. I don't know how that works, but sounds like something has to go out 60 days before the aggregation plan has been filed with the commission, if that's the initiating act. So
right, and that begs the question: is when does that happen? Just because it can happen in 23, does it mean it will happen in 23? Because we've decided that October 1, 24 will sort of be the beginning date of when enrollment could actually, customers could go on flow. So, you're not going to do an RFP and ask suppliers to, assuming that's what you do, whether it's suppliers or you're pricing out generation, whatever the county decides to do, normally don't do that a year ahead, because the pricing that you're going to get is going to be so loaded with risk premiums, you'll really not like the price that you're going to see. So, you're going to want to put out the RFP for whatever you're getting much closer to the, I mean, presumably if you're building generation, that's a little bit of a different scenario, admittedly, but I guess it's just really trying to understand what is the initiating fact, what's the trigger for the notice? Does it actually happen in 23 or does it actually happen in 24?
Okay, but that's a good point. I think we are also concerned about making sure that the CCA is actually initiated and in place because of the expectation that the SOS load is going to transfer to it. So if we wait until like the summer of 24 to start that process, that's cutting it very close with the SOS load being able to get taken over. So that's probably the reason to do it a year ahead of time.
Yeah, could we make up, I mean, I guess that makes me think of a different question though, Phil. I mean, and I'll stop talking in a second, but I mean, what you just said makes me think of another question. I mean, just because there's nothing in the statute, so the statute didn't anticipate this concept that we've come up with accommodating SOS and the transition and pushing it out to 24, you know, that's just something that we reached because we needed to deal with that piece. So I guess my real question is, even though there's nothing in the statute that sort of has this idea, could we not create some other, you know, notice by the county to the commission to sort of more formally say, hey, we're going to do this, but we're not doing it to next year, so that you're not triggering the customer notice piece of this, but you're signaling to the market that this is going to happen. You know what I mean? Like maybe like this interim, I'll call it like an interim commitment that notifies the market, but not customers, so as to create clarity amongst those who need to understand what's coming, bidders for SOS, and then, but doesn't create confusion for customers who are going to get notices so far in advance it would be very odd for them. That's just an idea.
Oh, okay, and I think that's a very good way to sort of think about how we prevent that from being an issue for customers. I know that as I mentioned at the beginning of the call, we are thinking about what happens in our agendas next couple of months. So I think we have to prepare to think about which rules, but also the application process, and maybe as part of that, that's what we'll think about the timing of when that occurs. But at this point, I think there's what the enrollment strawman's trying to get at is the utilities have to tell the county at some point what the address is or the contact information so they can comply with this requirement to provide written notice. I don't know that we have to determine that specific date right now, but I think we were saying it could be that could be as early as that. Whether or not, you know, after we review the process, it comes later on. But, you know, we got some law there that hopefully the lawyers can tell us how to comply with that. But I think we were just trying to kind of incorporate that along the lines of the utilities have some information, which is the mailing addresses, which may not be the service addresses, may not be the actual premise address, it may be a mailing address somewhere else that has to get to every account that is in the small commercial and residential in the state. So when that occurs,
I mean,
it may need to be that early. I don't think we were trying to say it is that date. So it's definitely a good point.
I mean, I guess the other thing it raises to me though, if it's a year in advance, you know, people move. 10% of the population moves every year. So, I mean, if you're focused on that particular piece, you probably don't want to get your address and customer list that far in advance because people move all the time. And so you want to be doing it closer to, from a customer notice perspective, you want that information to be much closer to the time when you're actually getting ready to transition customers and educate them. So that's just my final thought on that piece. I think to the extent we can have flexibility to figure this like weird year out, the 23 to 24 year out, I think that would be in everybody's benefit to figure it out.
All right. I'm guessing that a portion of the reason for that notice is also to let the county know that the county residents understand that this is going to be in front of the commission. If they have any issues with it, then they will receive notice of that proceeding as well. So probably do need to know about that so they have plenty of time for those who are interested to follow the application process or whatever hearing process the commission has to you know, approve those rates. All right. So let me just do that. So Leah, I think we'll make a note to sort of incorporate the timing of that issue as part of our examination of what the application process will be for the CCA. And
Thanks.
that may be the appropriate time to determine whether or not that notice, and the timing of it.
Bill, you have a couple of other raised hands, Michael Krauthammer and Lori McGilvray.
All right, Michael.
Thanks, Phil. Michael Krauthammer here representing Montgomery County. I'm not sure exactly where we left off. I think that was a very productive dialogue that we just had with you and Leah. So thank you for that. A lot of good points. It's definitely a very complex topic with a lot of moving parts. But to the extent we provide notice earlier, generally that's consistent with good government practices and keeping the customers and citizens and voters aware of what the county's doing. So all else being equal, the county's probably going to want to be having the option to notify folks earlier. When we look at the statute, the 60 days language immediately follows the provision, including the date of December 31st, 2023. So there's certainly, an implication at the very least that that the two are related to each other. We agree with your observation at the end about, allowing people to participate in the process at the commission and also to express their thoughts directly to the county. And then another point that argues in favor of earlier involvement of customers is that they would presumably want to know what's coming in a year, so that if they're signing a 12 or 18 or 24 month contract with a retail supplier, it seems reasonable for them to be aware of changes to the market that are happening. So we're not trying to influence people one way or another. Of course, customers are free and welcome to make whatever decisions suit their needs best. But if the county knows that a CCA is coming, a year or so down the road, at a date certain, it seems like just very responsible to let customers know this is coming so that they can also plan accordingly. All these points argue in favor of earlier notice rather than later, at least to the point that it's happening.
Hey, Michael, can I ask you a question about that? Because I don't disagree with anything that you just said. And I think last week when my colleague Mark was talking, he did emphasize the importance of early education. So, I mean, we totally agree with that concept. And so maybe that's something to think about in terms of how do we make sure residents are educated early so that they have time to plan whatever they're going to do and then have time to participate at the commission. I mean, there's more than one way to get the word out, right? I mean, so there's obviously this kind of formal notice piece that we're talking about, but I mean, I sort of have the assumption or presumption, and maybe it's not a good one, that the county is going to want to do something to do more customer education. So more than just a letter, they're going to find out about this from lots of different sources, right? So I guess I just throw that out there as food for thought. I mean, because I think we actually are agreeing on the need for that. It's just more of what does it actually look like, and how formal does it need to be? Can you start your customer education piece, next summer? Lots of much earlier to let folks know this is coming, and that way, when you actually make the filing in 24, presumably, they're going to have known. They're going to know about it. This will just be sort of like the formal thing that we're checking the box on. Just throwing that out there as, another thing to think about, maybe.
Totally agree.
All right. Was that it for you, Michael?
Yes, thanks.
Okay. And then Lori?
Thank you, Phil. I'm wondering whether there might be attorneys who could look at this question, because I do think there's an issue here of what needs to happen in that potentially November 2023 timeframe, for which it would be very difficult for the county to have information. So my reading is that this period, this at least 60 days before initiating the process to form a community choice aggregator, You have to have an aggregation plan. You have to give notice of the aggregation plan. You have to publish a summary. There are 5 things there. But where it gets awkward is in the fuller description of what that notice of the aggregation plan must include, which includes the commission issued license number of any selected electricity supplier, the terms and conditions, the new rates, all of those things, which if you haven't yet gone through the other steps in the process, it would be very difficult for the county to actually have that information. So I think the legal question is, do those things have to be all at the same time? Does the notice have to happen prior to the filing with the commission, where all of that information they would not yet have, I think, is supposed to be included. So I do think there's kind of a disconnect here, or practical problem, and I think it's a legal one.
I think that's a great point, Lori. Totally agree.
All right, Lori, that's a good question. I think so. What you're raising here is, what is the content of not only the first but also the second notice, and I think maybe you were sort of mentioning that with the first notice, I'm just looking in the section of the law here, or I'm looking at the bill. It's on the 7th page of this bill. It talks about, in this paragraph D, under 7510-0.3D, it says at least 60 days before initiating the process to form a CCA, the county shall, 1, develop a plan, 2, give written notice of the aggregation plan. And so, also publish a fair summary of the plan in the newspaper, put it on the county's website, and give for the commission's approval written notice of its intention to initiate a process to form the aggregator. So is what you're saying is how much of the information about the plan will be provided in that first notice? Is that sort of what you're getting at, Lori?
Well, yes, because if you continue reading down, it enumerates what that aggregation plan needs to contain, which is where all of this problematic language is, the aggregation plan shall provide details on rate setting and costs, and a number of things. So I think it's really a question of what constitutes the aggregation plan and how much of that detail needs to be in the plan at this particular point in time.
Okay, and I think that's a good point. I think, and I'm interested to hear if folks agree with this. I think for the purpose of our enrollment straw man, the contents of these notices, especially the first one, which might have some problems if we try to have all that information 60 days before the initiation of the plan is. I think we can, when we move to examining the process of applying for the plan and initiating it, that's definitely when we're going to have time to dig into all of this. For the purposes of the enrollment kind of process and the straw man here, I think the key element that we need is the utilities have to provide the ability for the county to send this written notice by providing the addresses. And I think there may be information that, in addition to names and addresses, that the utilities will have to provide, perhaps, but that's kind of the technical requirement that we need to get locked down here. The notice that occurs, the second notice, which I think is like that in paragraph F, that definitely seems to have information that, you have to have the rates and the terms so that the customers can decide what to do with it. But at this point, our focus for getting this straw man locked down, if folks agree, I think it's simply that these events occur, and we're talking more about the media of how the information is going to get back and forth to customers, and less about the content of what goes out. Is that fair to say? So, and I don't see any hands, so I'm going to just keep going on that. So I guess I'm going to make a note, Lori, to you know, when we look at the application process, trying to solving whether or not, you know, lots of detail about which retail supplier, if it is a retail supplier, is going to be sent at that time. I think we can work that out later, but for our purposes now, working through this document, I think we just have to understand that there's going to be a point in time in advance of the second notice that the first notice goes out, and that has to sort of comply with some of the other issues that folks are raising. So hopefully does that cover everyone's concerns on that? All right, so let me do this. So we've got 4 pages actually of the straw man to cover, and we've used about a quarter of our time, and we still have a couple more things on the first page. So I think we're okay. The next thing down, so this issue comes down to, I think, something that AOBA was very concerned about. And this, there's a little bit of a decision point here. And Fran, I'm going to let you sort of explain to everyone what your concerns are. But I think if I can just paraphrase briefly, your concern is that your clients will sort of be inundated with like information about this in such a way that would cause confusion for them, and you would like, number one, some way to exclude those your clients from the second notice in particular, and that you would like a way to sort of preemptively opt out, possibly in between those 2 notices, so that the county will have a pre-scrubbed list from the utility, and this is something the utilities need to tell us if it's doable or not, such that they won't even attempt to enroll an AOBA client or perhaps any other organization that wishes to do that. And then I guess what we're trying to make sure is that we're still complying with what the law says about sending something to every account for the residential and small commercial. So Fran, if you have something you want to maybe help flesh that out, and let's.
Please, I mean, Phil, thank you, because you represented that very well. The point that I want to add is when you're talking about master metered apartment customers, we must understand that many of these owners and managers own hundreds, if not more, apartments or communities or garden style apartments. It's not like a residential user. You send a letter, the owner or someone who lives in the house opens it and they see it. Many of these large owners have bill paying services, but there is one thing I can tell you: the people who receive and pay the bills are not the same people as enter into utility contracts. Any competitive supply contract is entered into by someone fairly high up in the organization. And what my fear is that these letters will go out. They may go out to different buildings. They may go out to different pay services. Someone sees a notice, oh, cheaper utility rate, check, and not realize that they are under contract. They're under a long-term contract. They've just negated a contract, will be subject to higher rates, will be subject to substantial penalties for all of the energy that was contracted for and not used. This will be a very difficult process to unwind once it happens, with the potential for some serious damages for inadvertent checking off a box or entering into something. In order to avoid that, I believe that large property owners, even though the buildings may be small, they may be full of small commercial non-demand accounts, that they should be able, after that first notice comes, to be able to say to their utility, nope, we are not interested in this. We have contracts one right after another. We do annual contracts. We do contracts for 3 years, 4 years. We don't want any more confusion. We want to opt out proactively. So we do think that this meets the intent of the statute, because it does say, I guess I'm reading part 3, little I, little 2, that one way of opting out is, of course, is by notification, but the second way is by having a contract in place. So any customer who has a contract in place should not be confused or burdened by receiving new rates in the mail that could cause a problem. I mean, I am sure Montgomery County will be putting these things on its website. There will be notifications going out. There'll be lots of education. They shouldn't have to deal with this over and over and over again. Just imagine what it's like for an apartment owner who's got 800, 1,200 small commercial accounts to have to go through and consistently, every time a contract is near due, trying to opt out. I think we need to be proactive in this.
Fran, I'll second your point. I mean, you know, I agree with everything that you just said in terms of the customer confusion, and arguably, I think this extends beyond just the AOBA customers and members. I think it's for all retail choice customers. I mean, I think we did flag this issue in the comments that we submitted as well. It's not just that we want clarity in these notices. I mean, we don't think that the opt-out notices should go to shopping customers, period. And so, I can't, we went around the horn of all the other CCAs that are active in the East states that we talked about last week. Nobody sends opt-out notices to shopping customers. It's just an invitation for confusion and problems. So I agree with what Fran has argued here, and I second that.
And I think that's key. Again, for all retail choice, that second notice call to action, you know, is just, you know, we think that that's going to cause confusion in the market for everyone. And it's not the intent of the Montgomery County was not to capture it. It clearly excludes third-party supplier contracted customers. So that's the idea, is that before that offer letter goes out, that list should be scrubbed from, and those, so basically it becomes just the SOS customer grouping as get to that offer letter. The way we do it.
Agree. That's also why we in the comments that we circulated try to make a little bit of a distinction of the notices. Grouping one is the notification of the CCA formation versus opt-out notices. There are two separate kinds of notices, and in our view, those opt-out notices do need to be scrubbed, because, I mean, even the call to action is different. If I'm a shopping customer, I don't have to do anything and I'm out. If I'm not a shopping customer, I don't have to do anything and I'm in. I mean, it just creates, from talking to customers and telling them what they're supposed to do, you can't have, you know what I mean? Like, that just inherently is a problem. There's a total conflict in just the action a customer has to take.
And we think the utility should do the first scrub. They shouldn't even go out to retail shopping customers.
All right, let me do this. I got two hands that I can see. So let me go to the hands, and then it sounds like we may have some questions to ask about the scrubbing process. We may need the utility. So I think Lori, I think your hand was up first, and then we have Jorge. So Lori, why don't you go ahead?
I just wanted to make sure to clarify here that all customers are notified of the existence of the CCA and their impending ability to make a choice, opt out if you're SOS, or change your choice on a third-party supplier, that all customers are notified of that opportunity, such that we don't find ourselves in a situation where customers are unhappy that they never knew they had CCA as a choice, because it is a choice just like any other choice.
Understood. I think that's actually some of the crux of the problem here, is that there is a disagreement about how to interpret that paragraph F. So, Lori, was that your point?
Sorry, I'm looking quickly at paragraph F, but
okay.
I want to be sure that
I think we agree with
the
that.
letter of the law of notification, and that, because one could imagine that people who have a neighbor that got CCA and they're like, oh, I got this great rate. And then someone else says, well, I never got notification of that rate. How come I didn't get it? You can see where the confusion can go the other direction.
Right. All right. So I guess what I'm going to try to do here is I'm going to try to get to everyone. And then it seems like this may be an area where we have somewhat of a disagreement. I may ask the judge how she would like us to sort of lodge that and then and develop a process for solving that may mean we do that inside the working group or some other thing. Jorge, you had your hand up, and then I see Lisa, and then I think I saw Bev as well. Go ahead, Jorge.
Thank you. Yeah, I guess on a similar thread, I guess this question was for Mrs. Francis. It is about choice. And I'm just asking a clarifying question because I think she intended it, and maybe I'm wrong, as how we write for a potential second contract, second retail contract. But the example that she gave is there's a property owner with 800 units or potentially 800 different households. And as I heard it, again, it's that property owner that makes the choice for those 800. So that's the piece that's a little tricky, because then again, I'm not suggesting that's what she said, but you could take it as then those 800 would not have heard, or they might have already opted out in the first retail contract. But what about new people that moved in, right? So what if new people came in? Does that just allow the property owner to choose for those?
What we're talking about is.
Anyways, hey, Ms. Francis, before you go on, let me finish.
I'm sorry.
Let me finish. Yes. So that to me, right? Like there's some clarification, and it may mean also, and I totally understand for some of these property owners having to set their own sort of rules and how they approach that particular question. But I would really hate to limit, right? To allow that choice. And I understand that those 800 households aren't the ones that pay. So there's like a third party even who is also maybe making this choice. That's not the household itself, and that there's contracts in place. But ultimately, I agree with Lori and just sort of reiterating that, yeah, right. Like one of the main things we want here is for people to have a choice.
Let me respond to that. We're talking about two different things. If you have a master metered apartment house that has, let's just say 300 units, the building owner pays the one bill. He is only responsible. The customers do not even see a bill. They have the choice to live in that building or to not limit that building. They are not a PEPCO customer. Second type of building, you may have people who have utility accounts with PEPCO, let's just say for cooking, and they will receive a PEPCO bill and they can choose whatever they want. There's no property owner that's going to choose for them. They make their own decisions. However, if there is a house meter that provides overall heat to the building or air conditioning or hallway lights, that is only up to the owner and manager of the building. And no matter what we do, no matter what the tenants want, if they are not getting a bill from the utility, they're not a utility customer, and it is only the owner manager who's the customer who makes the decision. So we're not even talking about that type of a building. We are just talking about buildings where the owner pays the bill, he's the customer, he makes the decision. Any other apartment property that has its own meter, I live in an apartment, I pay my own bill, I will make my own decision. But the condo association will pay the bill for the hallway lights and anything in the common areas, etc., and they will make the decision. We are only talking about right now a commercial owner of a small account that will be making those decisions. So I'm not trying to limit any residential choice. They can all do that on their own. And they.
And Mrs. Francis.
Yes, I'm sorry.
I was going to say, you said it's one, but you did say it was a property owner that might have one small building and then might have other small buildings. So
Here's the way it works.
that's where I got confused.
No.
No,
if
you don't have to
you
explain it again. I think you
No,
clarified.
if you have a garden style apartment project, you could have Spring Hill Lake on 495 that had 3,000 units, but they were in buildings of 8 units apiece. And those buildings of 8 units apiece were each a separate account. So that's why I said that that owner would have to opt out for each of those individual buildings. So that's why I said that. But there are owners that own many, many apartment complexes, many, and they will have to opt out for all of those small commercial accounts.
Lisa Brennan and Bev Sikora also have their
Thank you.
hands raised.
I'm sorry, I didn't hear you. Can you say that again?
She needs Lisa and then Bev. Lisa Brennan.
Thanks. I just want to make sure that whatever solution we come up with, that the CCA is going to be complying with this statute. Phil, I think you have the comment on this that says, is exclusion from F notice permitted by the law? And I'm not sure that it is. The law seems pretty clear that the CCA, the county shall provide or cause its selected electricity supplier to provide written notice to all residential and small commercial electric customers. And in that notice, further down, it talks about, they can give, they shall provide to the residential and small commercial electric customers the opportunity to refuse by basically opting out or by contracting with a retail electric supplier. I'm not sure that an exclusion is anticipated by this.
You read it correctly, and I see that, but part 3, little 1 and 2 does say that you can opt out is one way, the opportunity to refuse to participate by opting out or by contracting. And people who have contracted have already opted out. Just by the nature that they have a contract in place, they are considered, quote, opted out. That's how we read the statute. So I think what we're saying, I think is consistent, but you also read it correctly. So
Fran, going back up to F1, it says the county or its electricity supplier will provide written notice to all residential and small commercial electric customers. So I think we have to read those together.
I understand what you're saying. I think the way it's written is a little conflicting. I think that you are considered opted out if you have a retail and not part of the CCA, if you have a retail contract in place. You are not part of the CCA, you're considered opted out, or if you choose to opt out.
All right, Lisa.
I hear what you're saying. I need to make sure that the CCA is in compliance. So this may be something to ponder later.
Phil, I think, the situation I was gonna bring up might actually, I don't know if it'll answer this, but, depending on the timing of when the notice gets sent out versus when the actual, cut over when you become a CCA, customer happens, if that's even a month or two, what would happen to a customer who is with a retail supplier, but their contract ends during that, window in between? And, first scenario, say the contractor or the supplier doesn't renew their contract. That customer, they're going to get dropped in under, this law. They would go to the CCA. If they don't get the notice, they might not realize that why they're going to the CCA, or, even if they, the customer is contemplating whether or not to stay with the supplier, should they know that the CCA is an option so that they can make an informed decision about whether to stay with the supplier or go to the CCA or go to SOS. So there is that kind of situation where, a customer if this is not happening immediately, customers are going to change from being with the supplier to potentially not being with the supplier during that time period.
Bev, wouldn't that first initial notice about the formation of the CCA cover that note, so people ostensibly would be aware that there is a CCA? With the
Depends how
initial
long
notice?
it is beforehand. People may, if
That's
it's
what-
6 months beforehand, they might have forgotten.
Yeah, okay, but they would have gotten the notice.
Yeah, but
That's,
I think, I was just saying, that there is a reason why I think maybe they still wanted the second notice to go to all customers.
Bev, let me ask you a question about that. And I see Dave's topic's got his hand up. I'm going to get to Dave in just 1 second. So Bev, you're talking about the customers that may become or may roll off a retail contract between the first and the second notice, or after the second notice?
I was thinking after the second notice.
Okay, because I think we've sort of tried to anticipate how to solve that issue in the section, which is probably on the second or third page, that addresses how we're dealing with kind of post-transition. So I think what we're thinking of, everyone that opts out or changes status, everyone that changes their status after the second notice is going to be treated as if they're changing their status after October 1 of 24. Even so there may be, as a means of sort of sorting that out. So I think we have addressed that, and we'll definitely want to come back and talk about that, how that's going to work.
Yeah, I question if that's in line with the statute. I'm not, it is a way to deal with it. I'm not sure it's perfectly within line. That's, I think, a assumption, not a simple, an assumption, but that's a way we're dealing with that, because then you'd be forcing the customer to either re-up with the supplier for another year, or they might, it's just, it's a way to deal with it, but it's not the only way.
Okay. Well, I think what I'm saying is I think we're going to, when we get to discuss the kind of the post-enrollment timeline on the second or third page, we're definitely going to touch on that. Let me thank you. Dave, what did you have? Dave Hoppick?
Yeah, just a couple comments / questions. So looking at that initial notice that's going to go out before Montgomery County files with the commission, I don't, and maybe this is just my personal interpretation, I don't see that as including the rate for the CCA. It would be a notice that this is coming. And then, I guess I have a question for the attorneys on Section F. You certainly are opted out if you are in a retail choice contract. You don't have to take action, but is that the same as receiving notice? Are those the two the same? Can you automatically be opted out and be required to receive the notice?
no, I think that if you're opted out, you're opted out and you shouldn't have to receive any notices about what the rate is. However, in the first notice, I think you should know, even though you don't know the rate, you should say it will be a choice to enter the CCA. It will be a choice to enter SOS. It is a choice to not renew your energy supply contract. But if you have an energy supply contract, you need to do nothing and you will be considered opted out. So I think the first notice should spell out what the choices are. And hopefully Montgomery County will say, and we will post our rates as soon as they're available on our website. So they will know that the CCA is a choice that they can take.
All right, so Dave, I think what you're raising there is, I think it comes down to, and at least I see your hand up, so I think maybe you're going to respond to this, but I think we have a sort of a disagreement about whether or not the second notice, so the F notice, the paragraph F notice, which I think is the one that is expected to incorporate the opting out information on it, whether or not that must be legally provided by the CCA to every account that's otherwise eligible. And I think, Fran, what you're suggesting is you would much rather avoid having that information provided to certain accounts that have already provided a notice of opting out. So I guess the issue there is, can one still comply with the F paragraph by opting out before that would have gone out in order to sort of prevent any issues? So I guess that we may need to sort of define this fairly well and then get to a process where we can, get a decision on it either through this working group, perhaps through Judge Grace directly, or if that's something that's an issue, we take that to the commission. All right. So let me see. Lisa, you had your hand up, and then Fran, did you want us to come back to you?
No, I don't need to say anything. We may just have to agree to disagree or put some more definitions around it, but I'll just leave it at what I said. I don't want to burden it by repeating it.
Okay. And Lisa, did you have your hand up?
Yeah, thanks, Phil.
Yep.
So I just wanted to respond to David Hoppeck's question or comment. So the first notice that's in D, it talks about the aggregation plan. And there's details about what has to be in that plan down in D2. And that says that includes the rate setting and cost to participants. So I'm not sure we don't have to put rates in there, or at least how we're going to set the rates. It's an odd way of phrasing it that's different than the requirements under F, which specifically says new rates, charges, and fees. Up above in D, the plan is supposed to include the rate setting and costs to participants. So I just, I think one of the things when we do these definitions, Phil, is can we make sure that we are agreeing, what rate setting and cost to participants are if it's not the actual rates?
So and I'm looking on, this is page 7 of the bill, and it's in, I guess it's D2 III 1 is where you're talking about rate setting and cost to participants.
Exactly.
Yeah. So I guess, one way of looking at this is the notice says there will be an aggregation provided, within a certain year, but the ability to that far in advance actually provide what the rates would be, I think is where everybody seems to agree that is like that's hard to do, to set those rates that far in advance. So, Lisa, is your question then what's provided if we don't know that, or are you talking about maybe the process for maybe a description is like, we don't have the rates yet, but we're going to basically go through some sort of perhaps a bid process or something to obtain a retail supplier or some other means to develop a portfolio, and we'll have that, and that'll become available at some point in time. Is that what you're talking about, where the CCA or the county would sort of, as part of this notice, describe to customers, we're going to go out and seek a certain type of portfolio for you at a certain price, or prices, ranging from here to there, or that sort of thing? Is that what you mean?
That's when if those are different, and they are the words in those two sections. So yes, I was talking about comparing the language on page 7 with the language on page 9, which is F. Let's see, sorry.
F2 little 3.
F2 little 3, which has literally new rates, charges, and fees. So yeah, just all I'm suggesting is that it would be, I think, very helpful at some point to really define those.
Yeah, so I think we're sort of actually developing our next sort of work process. So as we're going through, I'm sort of adding some comments in, and I don't know if folks can see that. I just highlighted that second comment there. Obviously a little more details needed, but we need to figure out what information is going to be sent and when. think we've already figured that out. And for the purpose of complying with the law, I think everyone would agree that the second notice will actually have the prices folks are going to pay, because they're saying, you know, here's the rate that we've obtained for you. This is what you're going to start paying, you know, in 2 months if you don't take action to step away from this, or if you don't contract for something else. So that I don't think anyone's saying that we wouldn't have very detailed information about who the source of the supply is and what the rates are. The question is, how much information can be accurately provided at the time to comply with the D rate? And so that might be more of a qualitative description of the rates and how they'll be structured without actually having real numbers in there. But that's, you know, when our next move after sort of getting this locked down is going to be figuring out what information to provide, and then the format and, you know, how that will be relayed in order to avoid a number of the problems that folks have raised. Lisa, does that sort of, I think that's where I think I need to keep us moving here a little bit. And Lori, I saw your hand. We'll get to you in 1 second. But I think we're going to have to get into like a qualitative or discussion of what goes into these notices and when they're going to occur. But in order to make the notices happen, the utilities will have to provide certain information back to the CCA at the time that's, you know, agreed upon. If we end up with some disagreements about this, we need a process to reach a final decision one way or the other. So we'll probably need to start thinking about that as well.
All right, thanks, Phil.
Okay, and Lori, you have a.
I don't know that it can be done today, because I do think that it requires the legal department weigh in. But I've heard 2 things today around this second notice as it relates to entities that have an existing retail supply contract. I've heard the issues related to AOBA and mastered metered apartments, and I've heard the issue all other retail customers that are have an existing contract. So what I've heard is basically a proposal to have a de facto process by which those 2 categories of customers do not receive any second notice. So I just want to clarify that that is a proposal. And then, I have a concern for transparency of, you know, customers being notified of choice, but I think it's, as Lisa said, it's an issue around what is the required compliance under F. So I, for one, would appreciate understanding what's actually being proposed here and whether it is in compliance with F.
Okay. And Fran, I think I extracted this from your comments. These 2 little bullets here, I think we're talking about 2 things, and I think maybe Leah Gibbons also sort of agreed with one of them. So I think, Fran, you're definitely asking for the second bullet, where you're saying that you would like to notify the utility to sort of pre-scrub their list that goes to the CCA in order to remove the accounts that you've listed. So if you can say, look, these are all the accounts that we currently represent. These are the decision makers. And you've pointed out that there's often a difference between the billing address of an account and who actually owns the building, you know, for which that. So you don't want your purchasing department to be making decisions about this when it's actually something that affects an organization at a broader level. So you're saying, can we just opt out so that they don't get the list?
Right. After
Okay.
Thank you. You said that obviously correctly. After the first notice goes out and they say you have a choice for a CCA, you have a choice for a retail supplier, you have a choice for a standard offer service. You also have a choice to opt out of whatever you want to opt out from. And if you are on an SOS, if you are on a supply contract, you're considered opted out. I would like people who want to opt out after that further notice to say, we are now opted out, but we are opted out permanently. If we are opted out permanently and we're retail supplier, contract ends in June and we don't want to contract again till September. We want to go directly to SOS and then back to our next contract. So I think they should have the option of opting out once they get that first notice, so that the people who are in charge of making decisions can make the decision for the company and the buildings they control. You always have an opt-out option. You should be able to take it after that first notice.
Okay, and just to clarify, I think in your response to Jorge, you had indicated that these accounts would be commercial accounts that represent either the master meter for an entire building or for a common heating or cooling or common area account that is also. Is that
Right,
correct?
or yes, exactly, or a laundry room or a a rec room, whatever common areas that are considered small commercial accounts, not the individual residential apartments that pay their own bills.
Okay, so you're asking for that specifically, and Judge Grace, did you have a question because you just appeared?
I did, but also there's someone else with their hand raised. So I'm not a judge in this proceeding. I'm a facilitator. But we're going to be sending something to the commission that must follow the law. And so I'm not going to let anything go to the commission that's not going to follow the law. So we're going to get to the point where, like on this issue, there are going to be parties that object to what we come up with as a group. And when that happens, we're going to have to allow parties and ask parties to remember their objection and to go ahead and file something with the commission pointing out that objection. I'm just going to say that the notice in D is 60 days before filing with the commission a intent to go forward with this plan and an intent to have a aggregation plan, and it's going to include it specifically includes an aggregation plan. Unlike in F, where it's much later in the process, and it specifically includes the new rates, charges, and fees. Specifically includes a comparison of the new rates and the rates under the current SOS. And it also specifically in F, which is a much later notice, what we're saying our second notice is, it specifically includes the ways to opt out. Those are specifically not included in the section D notice. It may be too early for that at that point. So this is something we really need. This is definitely something where there are opposing views. We're going to have to address this before we send something final to the commission. Please, everybody, earmark this. But there's a whole bunch of other things that we need to get to today. And I see that Bev has her hand raised. Let's go ahead and try to get to those things and move on.
All right. Bev, did you have something quick that you wanted to?
No, thank you.
Okay. All right. And thank you, Judge Grace. I think that gives everyone an opportunity. Oh, Bev Sikora, you have your hand up. Bev, if you're talking, we can't hear you because you're muted.
One more thing quickly while we're waiting for Bev to turn on her mic. It under F1, it specifically says that it's the county that shall provide or cause its selected electricity supplier, if any, to provide written notice to the formation of the community choice aggregator to all residential and small commercial electric customers in the county. So we will have to give some weight to the county because this is a requirement on them. So we will have to give some weight to what their interpretation is.
All right, Bev, are you?
I was going to say, I agree that we don't want to send anything to the commission that is, contrary to the law. Unfortunately, I don't think this law was, and no law is crafted perfectly. And, there could be some areas where two lawyers can have differing opinions on how to interpret a statute. So, I think at a certain point, we might have to punt a decision to the commission. But then getting back, it seems like now AOBA has got two requests. One request that if you're with a retail supplier, you don't get the second notice. And then the second request that Fran just made is that the supplier can actually, I guess, affirmatively opt out forever, which again is different from just not sending the notice to customers with the supplier. Because I don't think it's going to say you can, if you're with the supplier, you never get a notice. It would be a supplier, I mean, a customer could say, never send me anything about CCA ever again.
They're two different things that we were recommending.
Okay, well, that's,
Right.
I just want to make clear. And
Right.
I don't think the statute does not address the second one. So that would, it just doesn't get to that. We'd have that be kind of an additional feature that we would be adding in.
Right, that we could do for regulation. It says you can opt out. It doesn't say how often you need to opt out. There's no parameters around it. So I would think that that could be handled in a regulation.
All right, so let me do this. Thank you, everybody, for that. I mean, this was a lively discussion. I think we will probably have an opportunity to delve into this further. I think we were responding to Lori's question as to what is it that folks are asking for. So I think these two issues that AOBA has raised, and I think are also picked up on by some of the retail suppliers. So like tag these. This is an area where if we have some disagreement about it, we will need to kind of work on that. I think this does not interfere necessarily with the kind of generic process in terms of the timing, but we may need to develop something that if there's agreement and everyone finds out that it's legal, I think there may be a need to develop some form of an exception to the standard process providing these notices. And that might mean I need the utility folks to think about how they would go about dealing with pre-scrubbing this, but you don't have to respond to that right now. But if we're going to do something along those lines, if we reach some sort of agreement, there's the process itself that I think this document lays out may need to have like an exception to it that sort of works out that way. All right, I'm going to keep going. There's some new stuff down here. Let me just highlight this. I think the utilities had asked in their comments specifically what is it that is going to be provided. So I think what Mr. Hoppick and I did yesterday when we went into this is for the purpose of the list. Now, just thinking about what is it that the CCA will need to use an enrollment. So remember, we are thinking about enrollments are going to work in the same way using the same process that a standard retail choice enrollment works. So that means that for these default customers that are coming across as part of the initial transition, the CCA is not reaching out to them and contacting them directly to get all their information. So whatever it is that they're going to need to enroll the customer, which certainly is going to be either the account number or choice ID, and maybe some of the other information that the utility has. So I want to make sure that the utility folks are that we address the questions that they raise. Does this do we need to be more specific here in this document for the purpose of enrolling customers with the list that is going to, and again, not worrying about the ones that we're going to exclude for some of these other exceptional reasons, but for all the customers, say all the residential customers in particular, do we need more information here about what needs to be provided in addition to just generically saying, look, we have to tell the CCA their account number. We have to let them know if they are on a retail choice contract, and we need to give them any information that is necessary to communicate with them. Now that might mean just a mailing address, but it also might mean email or text information, something of that nature. So just, back to the utility folks. I think the question you raised was particular what gets provided, because I guess you're the ones that have to provide that. Did we capture that, or is there more to it?
This is Robbie for PHI. Just one clarification question. So the first list that goes out, will that have different information than the enrollment list?
Yes, I don't think we're going to need anything to allow an enrollment to occur, just to allow written responses to be sent. Now, written, folks can tell me if that means just snail mail or if it's actual or email. But I assume, Robbie, that what your folks would have is the mailing address for each account for sure, whether or not you also have a email address or other forms of contact.
Okay.
So you wouldn't be sending an account number the first time.
Okay.
Now, the question that I think, I don't know that we ever wrote this down is it just as easy for you to send that information the first time and then regenerate that list with any, additions or deletions for folks that have moved the second time, rather than trying to like update it in some way and add the additional information? Is it just as simple to?
Yeah, that's what I was thinking.
Okay.
Yeah.
So the first list would just be whatever is necessary to comply with sending a written written notice. So I don't know. You do have customers that don't receive bills in hard copy, right? You have customers that only take electronic copy.
Correct.
So for those customers, do you still retain a mailing address?
Yes.
Or we'd be,
Yep.
and this is something that I don't know we have to solve this implementation issue right now, but if you're sending contact information so that the CCA can reach the customer, would you be able to send both an email and a written or a mailing address? And are there folks that have other forms of electronic contact aside from email, like text or something else? Robbie, if you're talking, I can't hear you.
No, I'm thinking. Sorry.
Oh, okay.
Phone
we
numbers?
need an icon for that. Go ahead, Bev.
Well, no, we have phone numbers, but I don't think, text is generally pretty limited. How many characters you can send in a text message, or even a voice, a robocall. So, we have that information. It's just, I don't know that that's gonna be useful.
Yeah, it's more for storms for the text and the phone calls.
Well,
Well, I would probably we need to ask the CCA how they want to reach out. If they want to reach out with mail, postal mail versus email versus something else. I'm just sort of trying to maybe think about if you're going to dump an email list somehow. And Robbie, have your folks thought about how you might do this? Do you have a way to extract this and put it into like some type of text file, or do you know how you would do this?
I know we probably do it through an Excel spreadsheet. I'm trying to think how we do our Delaware customer list. I think it's through an Excel spreadsheet.
Okay. Can a spreadsheet in Excel hold 200,000 records? Or would you have to break it up by letter or something?
Excel goes to 1 million rows. This is Dave.
Okay. All right. So
The answer is yes.
Your system might be able to dump it into a file that's like Excel with information in cells and accounts going in down the road.
Yeah.
Okay. All right. So I guess we were trying to respond to your question was like what gets provided. So I think we still have to work out what exactly goes into the second one in particular, but the first one was definitely going to have whatever's needed to send the written notice, and then we have to see if everyone's agreeable what written notice means.
Yeah, I don't think we didn't want to have to create two separate lists, one for the initial, then one for the actual enrollment. I'm sure there's gonna be a cost associated with both to exclude information, then put the information back in to generate the list.
All right. Well, so
we can look at that.
If you if you send the first list, which is just mailing addresses, let's say we skip email for now. That'll be a list with like name and street address, city, town, zip, that sort of thing. The next time you send that list, it's going to have more information in it. It's going to have the account number for sure, and maybe whatever else is needed. So you would maybe generate that first list and then change whatever process kicks out the list and add the additional information the second time?
Correct.
Okay. All right, the second, and if that answers your question, let me know, or I'll just keep going.
It does. It does.
Okay. The second question I think the utility folks had is is the scrubbing process. Do you want to maybe explain that a little bit, what your concerns were? I think on the utility comments on the first page, down on the bottom, there were two comments. One says the bill does not seem to suggest that the data is only for a scrubbed list. And maybe that was addressing the historical data, not the actual customer list.
No, I think that gets to the question of, Fran's, question of, do we scrub out people who are with retail suppliers? Do we scrub out, other people? And is that really on the utility to be doing the scrubbing of the list before we send them to the CCA? Or do we send all that to the CCA with whatever information we decide should be included, and it's up to the CCA to figure out who to send the notice to?
Right, because
Thank
we'll
you for the
identify those
question.
customers who have we'll identify, customers on a retail contract, and then they can just filter out, the ones that they don't want to send the notices to.
Okay, so from the standpoint of scrubbing the list, I think the way this is written is the utility is going to scrub, or sorry, the CCA is going to scrub the list. The utility gives the CCA everything they need to comply, which, unless we make further decisions on it, at least for that second list, you still have to send a notice to everyone. I know folks are, I'm not trying to go back over that because I know folks disagree with that. So the question is, if the utility is not scrubbing the list at all, but you're tagging the accounts that are currently on a retail choice at the time the list was generated, that's, I think, the minimum thing we need the utility to do.
Right.
And then when the CCA is going to develop their process for sending enrollments, they're definitely going to scrub out everything that's tagged with a retail choice contract. But there's going to be some exceptions, and I think Bev, you raised this. There may be things that change during the let's say the 60 days before October 1. So like August 1 of 24, if the CCA receives the list, maybe they got a little earlier because they're sending a notice out. But then at some point, you get towards the end of September, they're getting ready to send those enrollments to the utility. They have to scrub the list they got from the utility to remove the customers that have either opted out or who are currently on retail contracts. So there's a couple of things that have to be done there. So I'm getting from the utilities question, or maybe the utilities position, is that you would not want to be in the driver's seat for doing any scrubbing, but rather you would expect the CCA to do that. Is that correct?
Correct. Yes.
So I think we are, the comment or the process here is basically having the CCA doing the scrubbing. And then what Fran had raised earlier is the utility going to be able to pre-scrub that list based on something that AOBA would like to see happen, sort of to kind of permanently remove oneself from that eligible list. And that's the issue that we need to sort out. But in the event that the utility had to pre-scrub the list, that second list would be generated by the utility to either tag accounts that have already opted out, or remove them. And maybe it's easier to simply develop certain tags to attach to each customer account to indicate, well, one, here's a tag, it's on a retail, it's a TPS account, I think as PHI refers to a third-party supplier account, or it's tagged, or maybe it can be tagged with both. It's a TPS account and it's been tagged as opted out ahead of time. And if the utility receives a desire to opt out before that second notice, can you act on it in that way or not? So that's kind of, without saying whether or not you should, I think what we need you to think about there, Robbie, is whether or not you're able to develop some code that will develop the list and then tag certain accounts with variables indicating them being a TPS customer or them being on a list of folks that have requested to be opt out ahead of time before the list was sent.
Phil,
Yep.
Can I just add something? One of our concerns, and we've been telling our members for 20 years, treat your utility account number the same way you treat your social security number. That is confidential information that you want to have control of, which is why when we sign competitive service contracts, each time we get bids, we have to sign a new form. And that's in the regulations, and we all do that because we want to keep control. The utilities have those account numbers, and I see no reason why, after we get that first notice, why we can't opt out and keep our data confidential and not have it sent to anybody. We want to control our account numbers, and I think that would help us do it, be able to opt out right from the beginning and have the utilities have the first scrub of the list. If we're under a contract, we're considered opted out. It should stop there.
All right, Fran, I think I definitely have heard that, and we're making a note that this is something we're going to figure out a way to reach a resolution on.
Thank you, Phil.
Where I think if I'm correctly interpreting the second, and this will I think let us get off the first page. In the joint utility comments, the second comment said there may be system limitations on how much historical data can be provided by EDI. So I think that is addressing, and Robbie, let me know if I didn't catch everything regarding the first question about scrubbing the list. But
yeah, just one thing real fast for the ones who opted out. Now, if they contact the CCA directly to opt out, we will not have that information.
right, you would.
Only if they call the utility to opt out would we have that information.
Yeah. So I think what I was trying to ask you is, and maybe we didn't incorporate this earlier, but if you were to receive a phone call prior to August 1, when you have provided this list, if that's the date, for the second notice, if a customer calls you up and says, hey, I heard about this CCI, I'd love SOS, I want to stay on it, opt me out. Do you have the ability to tag that account and say, we've received an opt-out notice for this? So
yeah, this time, no, we don't.
So that's
we have to develop that.
Okay. And
hey, Phil, Ashish, BG&E. So sorry, I joined late. So BGE does have a customer list that we develop for marketing purposes for suppliers for currently. So we're thinking this will probably be a modification of that process. And we do have an opt-out process in place for customers.
Okay, great. Well, hopefully that's not something that is going to create simply a technical hurdle or an expense hurdle, because we still have to figure out whether or not we can actually go ahead with that. Fran, did you put your hand back up, or is it still up from before? I didn't see. Fran? Okay, it's down again.
No, sorry, I'm having trouble with the hand.
All right. So moving on to the last item here, I think the comment that the utilities raised was that it gets to the requirement. I think this is in paragraph M, that the CCA can obtain historical data for the eligible accounts. So I think what the utilities raised is, it doesn't say that that has to be scrubbed. So that means that, and I think the language talks about permission is deemed to have been provided for all accounts, and not regarding whether or not they've been opted out or scrubbed or anything. But I think maybe that's something that also is a sensitive issue for some accounts, or maybe not. Bev, was that your account or your comment?
Phil, I think that was mine. That was just Ashish
Okay.
again for BG. I'm not so I need to circle back with my team. It was just a comment that I put in there. I'm not sure how far back we can go in an EDI transaction. I just need to figure that out. So it was just I sort of make sure we noted it, and I'm not sure if it's a concern at this point or not, but I figure I put it in there.
Okay, thank you, Ashish. And I think Dave and I were talking about this yesterday. When you send information on historical usage currently, so if a customer provides authorization to a retail supplier, the retail supplier can request historical information. Is that done using EDI? for BG&E, or is that done using some other means like a download off the website or something?
I think it could be done through EDI, or it can be done through our CD Web, which is our portal, our supplier portal.
Okay,
Is EDI for PHI.
it's EDI. And does that get expensive if you're doing a lot of accounts?
Hmm.
There's fees associated with the EDI transaction, or is there not?
There is.
Do you have a feel for the idea of requesting that for 200,000 accounts would be expensive or not expensive?
It will be expensive.
Okay.
Yeah. Based upon the, current volume today versus that, yeah, it'll be very expensive.
Okay, because I think we were reading the tariff that indicated something like, was it like a couple of dollars per transaction or $1 transaction or something?
Oh, you mean to charge the supplier for that? I'm thinking more like our monthly bill to our EDI provider versus that.
Oh, okay. So you don't charge.
For expenses that we would incur to generate that we pay.
Okay, so if you were to send, and I don't know how much information, I don't know if you need just monthly billing in kilowatt hours, or if you need 24/7, 365 information about load in order to allow the supplier to understand what they're going to be obligated to provide. But are you for a residential account, would you need to send anything aside from a monthly kilowatt hour read in order to allow a supplier to make an accurate estimate?
I mean, they'd want more information than just the monthly read. They want the load profile code, the PLC values, transmission values, bill cycle, etc.
So, to the extent that request comes through, you would probably be incurring an expense that in order to transmit it via EDI.
Correct.
Okay.
And-
Yeah, you have your
And then,
hand up there.
yeah, on the flip side of that, Phil, I was just thinking, I mean, and Robbie, maybe you know the answer to this better than I do, but I mean, you would incur an expense for sending it through EDI, but as a supplier, whoever the supplier is that's ingesting that information also incurs a fee, don't we? I think we do for the EDI transactions. I think it happens on both sides, doesn't it? I kind of feel like it does.
I think so. I think you'd get this because you'd have your own. Each supplier would have their own EDI provider, right? It would.
Yeah. Right. So whoever's helping the county is also going to get the fee. No, right. You wouldn't charge, but the EDI
supplier,
provider, right?
Correct.
Yeah.
Your vendor may charge.
So it does happen. The only reason the only reason I'm flagging it is because the fee that, since Phil's asking about the fee, it happens on both sides of that transaction. So just for transparency, everybody knows what that means.
Okay, so I think the comment we were sort of trying to address there had to do with limitations on providing that data, and I wasn't sure if that meant technical limitations on how many you could request per day, for example, or if it's more of a cost limitation as well. But probably just making a note there, and especially for the folks in the county, when you're talking to your technical people or folks about on the supply side, what sort of information will be needed to allow whatever supply portfolio or supplier you're developing to get a good a good sense of what the load obligation is going to look like. Are you going to need detailed information, or is load profile going to be necessary because there may be a significant cost that either gets worked into fees or the program cost itself that we need to figure out? So just sort of tagging that ahead of time. All right, so with that, I'm going to move off the first page and moving on to the second. Just coming down here a little bit further. All right, so I think the first question or the first comment there is, I think there was, and I think I'm thinking the utility folks may have had this question. there's a certain period of time where enrollments have a I guess they have a transaction sort of cycle that they go through. So if the enrollments are targeted for October 1, I think that's a Sunday in 2024. Is there any particular reason not to start enrollments on Sunday? Or do we otherwise need to account for the fact that this should occur during the business week?
It has to be a business day.
Okay, so if I think October 1, 24 is a Sunday, so that means we really are starting October 2nd for the purpose of allowing you to process those. And then I think the other question that we were trying to pick up there is, I don't know if I got this a little further on down or not. Is there a particular, and this is probably an implementation detail that you can sort out, but if I think with the utilities, we're trying to avoid trying to process more than 10,000 accounts on a daily basis. Is it a reasonable schedule to process those as they come in over a rolling time frame, or is there a need to sort of send all of them to the utility in whatever batch size is appropriate, and then let the utility process that at 10,000 per day? Do you essentially want to kind of in and out sort of arrangement where you send 10,000 each day and they get enrolled each day, or do they need to sort of, can they all come across? Is that something we need to worry about in our process now? Robbie, I don't know if that's something you
Yeah, I think we were thinking 10,000 per day. So each day we would receive the enrollments.
And they would need to arrive, if we're trying to process beginning on a Monday, the first Monday after October 1 is the 2nd. When would you expect those to be arriving?
3 business days prior to that date.
So like the Wednesday before, maybe?
Correct.
Okay. And then they would just roll going forward. So they would be a gap. You know, so they would just start arriving. And so Monday's the 25th. So we're really looking at the 27th is the day they start arriving. And then you just process them as you go.
Correct. So they would all have a different start date.
Right.
Right. Okay.
All right. All right. Are there any questions about that? I think I want to make sure we covered everyone's comments or concerns about that. I know there's on the utility comments a little further down on this page, there is a question about how will customers know they're being rejected? That's a little further down here. So on the utility, the comment on the utilities document is from MVA3. Do we have the person with that comment on the line? The question is, how will retail accounts know they're being rejected? And then there's a question as to whether or not a rescission period is required. Somebody on the joint utility.
Bill, I was just going to say, if you scroll up just a little bit, we might be able to see what they're.
Yeah, I think that was me. This is Valerie with Potomac Edison.
Okay.
I think the wording was a little bit confusing, and it sounds like it's after the enrollment, some kind of notice is going to go out, but I wasn't sure if they're rejected, where that notice was coming from. Or am I misreading it? Like,
okay, so I think, and this is probably an area where I'm glad you've sort of raised some of these issues. This may get to some technical implementation questions that we can solve. I don't think it interfered necessarily with the schedule here, but so let me just ask. I think the bullet that I've under this comment PV5. So this is talking about the enrollment process, where what we're trying to manage here is if you have a customer that is on retail choice, they are, and they don't respond to the notice from the CCA. They're just going to stay on the retail choice contract, and they wouldn't get any notice of anything happening. if you have a customer that is on SOS and they take no action, they're going to get enrolled in the CCA. So it's somewhere around here. One of the questions we were trying to figure out, normally, my understanding is the utility sends each customer a letter indicating when they have switched their supplier. And I'm not sure if that's solely from when they switch to a supplier or also when they switch from one supplier to another. Is that still correct? Does the utility still provide that bill? I think that was actually something written into the regs at one point.
Yes. We do.
Yeah, that's true.
All right, so just thinking about how this rescission period or how this transition is going to occur. So for each account that defaults to the CCA because they're an SOS account that does not respond one way or the other, is it the utility's intention, or maybe your system will just automatically do this? Will the CCA customer get a letter from the utility saying, "Hey, you've been switched"?
Mhm. Yeah, it's a regular enrollment. So yeah,
Right. Okay. Okay.
Uh-huh. It might be a special letter just, indicating they're part of a CCA. They might need to be created, but they will get an enrollment letter from the utility when they switch to a third-party supplier, regardless.
Okay. And that is that's probably still required by the regulations, right?
Correct.
Okay. So to the extent that, and I don't know if the county has any thoughts about whether or not at this point, and I don't remember if the law requires the county to send a notice upon that enrollment as well. But Lisa or any of the county folks, has the county sort of thought about whether or not they will be sending a notice at this point?
This is Lisa. I don't know that we've thought about that at this point. Can somebody point me to the reg, just because I'm curious what the utility's going to send? It doesn't have to be right now, but if somebody could shoot that
Probably
to
in
me at some point.
Comar 2053, but I couldn't tell you which section.
Okay. If somebody could shoot that to me at some point later, that would be fantastic. I don't think we've thought about that yet.
Okay. All right. And then let me sort of ask about the comment about the middle bullet. Sounds like a rescind period needs to be determined based on post-transition enrollment. This is counter to instant connect. The wording is unclear. Can I ask the folks to is this the right bullet number words, or what was the concern about it? And I don't know if you're talking about a rescission period or an opportunity to sort of reject being enrolled by the CCA.
Yeah, let me think. I think that was regarding the OOPS transactions, the EB 1, 2, and 3. So if a supplier enrolled a customer, or if the CCA enrolled a customer and their old supplier said, no, that customer belongs to us, can they still do the EB, I guess the EB 2 to pull that customer back?
Okay.
And we assumed it would be a yes.
This
those
is
transactions would still be in operation.
Can you just so everybody understands, because I don't know that EB2 is a this is a situation where an enrollment occurs with a customer that's on retail supply. You send a drop to the original supplier, and then they respond to that drop saying, no, bring it back. Is that what that is?
Or reinstate, correct, yeah.
Okay, so it's reinstating, so it's sort of rejecting the drop as a result. And that's something that you accept automatically, but it is the responsibility of the first supplier to basically have contacted the customer and asked them to rescind the enrollment with the new supplier. Is that how that works?
No. I think with that one is if they get the drop, they can issue that transaction to pull them back without talking to the customer. The customer can issue a rescind by calling the supplier to say, I don't want you. That's the EB1 transaction, I believe it is, to rescind or to drop or reject that enrollment from that CCA supplier if they wanted to.
So how is it that, so if a customer enrolls with a new supplier, breaking their old contract, how is it that the original supplier can reject the drop and keep the customer?
Because we send a drop to that supplier and they'll say, no, we have a contract through 2025 for this customer. They cannot be dropped from us. So they can reject the drop and reinstate that customer.
Okay. So we could have a scenario whereby a customer receives that second notice from the CCA, contacts the CCA and say, you know what, I want to be on the CCA and I want to drop my old supply.
Mhm.
And so whatever process we're going to use to manage that, which might be something to the effect of the CCA has to send the utility an enrollment with a code that says, yes, I know this customer is on retail supply, but they called us to sign up with the CCA. We could still have that customer have that drop get rejected and end up with their original supplier and not get the CCA unless you sort of change something in there to prevent that from happening.
Right.
Okay. Lori, I see your hand up.
So I was unaware of this, so maybe folks can clarify, but I thought with retail choice contracts that typically a customer could elect to drop the contract before it ends. And usually that triggered a penalty of some kind, a payment.
Mhm.
But I was unaware of contracts where the customer is bound to retain that contract and cannot be dropped before the end date, such
Mhm.
that even if they request to do so, they'll be rejected.
Yeah, we see that more with our large commercial customers, but we wanted to bring it up because these transactions do exist and suppliers do use it for some of the residential customers. So we want to make sure that it was brought, to everyone's attention that these will still be in effect.
So it does provide some communication opportunity or challenge that if there are customers upon learning that the CCA is coming into existence, say in November of 2023, that they have to be very mindful if they wish to elect to join the CCA a year or nearly a year hence, that they have to be very mindful of what their retail choice contract says, such that they don't assume they can make a change and join the CCA if in fact they're going to be rejected from doing that. Is that correct?
Correct. I mean, it's the same way with a residential customer. So if they did not opt out and then they're part of the CCA, the enrollment comes in, they receive their letter, they can call that supplier to reject that enrollment, say, I do not want to be part of the CCA. And the supplier will issue an I think it's an EB1 transaction to cancel or rescind that enrollment.
But
This
it
all has
really
to
comes
happen.
down to what's the nature of the contract that the customer has with their retail supplier.
Yeah, and again,
Whether
this
or not
happens.
it's penalty driven or whether or not once you're in, you cannot get out.
Right, and this is also a very small window. They have like up to 2 business days to do all of this real quickly.
Okay, well, it
Yeah.
just enhances the kind of communication that the county may need to do with customers so that they really understand what their opportunities and challenges are. Thank you.
Exactly. So part of the customer education process is, review your contract before you make a switch. Yeah.
There isn't anything in
Thank you.
the
That's helpful.
is there anything in the law that kind of in the CCA legislation that puts any restrictions on the ability of a contract to? Is there anything in there? I mean, that might be something to make sure that one can still do that while the CCA law is in effect. But, all right, so Robbie, this is something that we will probably need to get into to examine how your systems are going to work, and then quite possibly we need to understand if there are accounts that are I don't know if there's a way to figure out if there are retail suppliers that are operating in a mode where they would in all circumstances reject a switch using this process, because the customer and the customer, from my understanding, and Robbie, if you understand, you can let me explain whether or not this is still an issue. If a customer calls the retail supplier and says, drop me, and the supplier doesn't take that action within 3 days, the current rules allow the supplier or the customer to call the utility and request that drop after affirming that they've attempted to reach their supplier and the drop was not executed. Is
Correct.
that still the case?
Yes.
Is there a way for the utility to understand that that particular drop can't be rejected, or can the supplier reject that type of drop as well?
They cannot reject that one because that's not part of the enrollment process. That's just a customer calling in to say, I no longer want to be with this supplier. And they got no response from the supplier, so they call the utility for us to initiate that drop.
Okay, so the EB2 process that's mentioned,
Right.
that's
That's just for
solely,
enrollments. Only
that's
for
actually
enrollments.
that's kind of the error transaction, right?
Correct.
Where
Correct.
an erroneous enrollment has occurred for some reason, and the supplier is, without involving the customer, saying, look, that must have been a
Correct.
mistake. Okay. So
Right.
this isn't,
Or for the customer to rescind the enrollment. So they call the supplier to say, I do not want that enrollment. Please cancel this contract. Put me back to whoever I had before.
okay.
Yeah.
All right, so it's not necessarily something that's tending to overrule the customer's choice in the matter. It's attempting to
Correct.
prevent like a mistake enrollment from sort of being executed.
Correct.
So for anyone who's interested, this is in COMAR 20.53.06.07D is customer cancellation if the supplier doesn't cancel and the customer wants to contact the utility directly.
All right. Okay, so let me just, I think the new stuff we added is the purple down here. And this again was sort of trying to react to the concerns that folks had raised about this. So this bullet here is I think Robbie, you've already confirmed that this is at least how PHI does this. So if a retail choice account, and I guess any account that ends up on the CCA, they're all going to get letters. So I can probably clarify that so it's not just the CCA. And then I think if the original third-party supplier, after receiving the drop for the CCA, and I think we had written this down earlier, but I think you've already confirmed it, that if that original third-party supplier then sends or sort of rejects that and sends an enrollment, and I'm not sure if incumbent enrollment is the correct term there, that will return the account to the original TPS. So basically that functionality will continue to exist. If somehow a customer signs up for the CCA, or if that customer is inadvertently added to the enrollment list, and the third-party supplier can sort of fix that if they think it's an error. Correct. So that's something else. All right, so I think that was what we were trying to respond to in the utilities questions about this section. So let me know if there's anything else that we missed that otherwise are picked up there.
So Lori McGilvray has her hand raised.
Oh, okay. Lori?
I'm sorry, that's old. I'll take it down.
Okay.
Apologies.
All right. And I think we may have added this additional bullet here just to clarify something we already, I think this got added. Such that.
Can I interrupt real quick? This is Misty with Potomac Edison.
Yep.
Judge, could you repeat that COMAR again one more time?
Yeah, let me flip to it. It's 20.53.06.07D. That was just specifically to where the customer contacts the utility directly when the supplier has not canceled the service.
Thank you.
All right, so I'm going to move down here a little bit further, and I think this next comment here is in response to, I think we just duplicated this. We've already sort of covered it. For the purpose of sending the enrollment information, a utility is going to provide the data on that second enrollment list, or on the notification/enrollment list, account numbers, choice ID, address, etc. And that comes with the second list, which is the F paragraph list. I think we already picked up, but I think we added this again. All right, so I'm going to move off of this third page, and although post-startup enrollments is unfortunately at the bottom of the second page, it's the topic of the third page. So the comment here, I think there's a number of folks that raised issues about these, the kind of the various proposals we've got for the kind of the post transition enrollments and then cost recovery. So, and I think this also responds to Montgomery County's questions about asking the utilities. We got a number of options here. What is, and to the extent that either the county or through cost recovery associated with the CCA, that those program costs are gonna be recovered from Montgomery County customers. At what point, and I know that this is sort of asking a tough question this early in the process, but have the utilities in any way begin to think about what some of these options are going to cost? And if not, what would be a good kind of approach to sort of developing a way to understand how much the various processes are going to ultimately cost the utility and then need to be recovered? So I don't know if any of the utility folks have sort of picked up on that as an issue. I think the utility comments have probably raised also that, hey, we need to understand who's gonna pay for all this. And I think the county certainly has concerns, if I've correctly interpreted their comments in the one email, as to what is the process by which these costs will be recovered and how much is it going to be. So before we kind of dive into the kind of the second half, the back half of the document, is there any preliminary cost estimates available? And if not, what's the best process for to sort of developing this? And I guess maybe I'll ask the utility folks to sort of comment on that first.
Hey, Phil, Ashish for BG&E. So, I mean, we haven't actually gone into cost estimates yet. I think, I'm not exactly even sure how to get this process going, right? I mean, I think we need to have maybe final requirements to give to our teams to be able to develop something. I don't know what others on the call maybe if they have other thoughts. I think before we can start looking at cost estimates, I mean, we need to understand what's changes are going to be needed on our end, right?
Okay, that's fair. What I might, and I don't know if any of the other utility folks are going to answer, but Ashish, while they're doing that, to the extent that seamless move development is kind of proceeding in order to comply with the July 122 date, have cost estimates been developed for what seamless move is going to require?
Yeah. I don't have the numbers off the top of my head, but yes.
I don't
cost estimate
with perhaps maybe it's a big assumption, but to the extent that, say, the instant connect feature is similar in its sort of development scale as what seamless move looks like, or possibly benefits from the sort of concurrent development of those, does that give us at least some sort of ballpark idea of what it's going to cost for at least
order of magnitude? Probably. Yeah, let me do this. I can circle back with our IT folks to see if they can develop a rough estimate and maybe utilize what we did for seamless moves, right? If we get their thoughts on it and get back to the work group, at least for BG.
Okay, that sounds good. How about PHI?
But so Phil, so just but that's one piece of it, right? Are there other things that we need to do? I'm not. We'll have to. That's the part maybe that we need to think about.
Understood. Yeah, I mean that's only one of the options, and there's probably other things. But I think what we need to understand is, like as you're saying, if it's about the same or at least, order of magnitude, I guess is, somewhere around, is it 10 times or 100 times? That's still
Right.
not
Yeah.
super accurate, but I mean, the number that I've heard kicked around for supplier consolidated billing is on the order of like more than $15 million, depending on which of the two options or approaches in terms of timing. So that gets very expensive for something of this size. So I don't know if, how.
Yeah, let me see if I can on the call while we're chat. Let me see if I can find the estimate for seamless moves, at least for.
Great.
And yeah.
Okay. And I understand is that that's not a full summary of everything needs to get done. We will ultimately need to understand how this is affecting each utility, and that will probably have a big role in selection of some of these options if we also understand how the cost recovery is going to happen. So I don't know. I'd like, to the extent if any of the folks from PHI or PE would also like to comment on that. If there's anything different you'd like to say, please do so now.
This is Taylor from PHI. I think Robbie had to drop. He's got a conflict, and I may be the remaining person standing from PHI. So I think we're in line with Ashish, just because it's not really clear what it is exactly that we're needing to get, it's hard to come up with estimates, but to the extent that we can get our seamless moves quote, I can follow up with Robbie and the IT team to see what that is. But I think we definitely need to get a little bit more clarity before we can provide an actual estimate that may be workable.
Okay. Well, I think, I know it is somewhat of a heavy lift to try to, make these estimates without knowing precisely what all the functionality looks like. But unfortunately, we're in a spot where we are maybe trying to select sort of a functional process forward without knowing, ultimately what things are going to cost. So we'll sort of maybe do what we can with estimates, and then hopefully that will.
Yeah, it's something we definitely want to be considering, but how much weight are we giving to the cost? Is it going to is that leading the decision? Is that merely just a part of the decision? What does the county want to do? Like, does the county have anything they're particularly leaning towards for whatever reasons they may have? I guess that would be good to know.
So, if Lisa or any of the other county folks want to jump in, here's what I think we might want to do with sort of figuring out how cost is going to impact the implementation. We know this program, I think, is going to have goes into effect in 24, and I think it ends or it's going to run through something like 2030. We have a general idea of how many folks are going to start in the program. And so we can use that as a means to, let's say we use a POR discount rate we can probably figure out how much cost can be recovered from the customer base annually using, what maybe is expected as a reasonable, monthly cost that gets worked into each customer's bill. And we can probably build up as to how much, what becomes unaffordable. And, I don't know if that screens out options or if it kind of gives us more information, but we sort of have to make a decision about which of these methods is going to work. And if one of them's very different than the other in terms of cost, that probably will have some bearing. But at the first, crack at it, we know that retail choice discount rates are either 0 or, possibly 2 or 3% at most. So if cost recovery for this program goes outside that range, then you're sort of automatically becoming uncompetitive with probably both SOS and retail choice, and then that can become a problem. So there's some number crunching to do there to figure that out, I guess. But I didn't want to.
Oh, go ahead.
No, go ahead.
I was just gonna maybe ask a stupid question, but we're talking about costs that would be borne by the utility, correct? Not because my thought is to some extent the CCA has to bear certain costs.
Well, cost allocation.
We still need to work that out. So
the allocation of the cost is also, I think when I was giving you sort of that bottom up example, I think where there's some sort of assumption that an allocation of the utilities cost to implement may get picked up as part of the programming or system related cost recovery as part of the discount rate. Doesn't mean it's all of it, doesn't mean it's, you know, most of it. It means it's, you know, there's typically some proportion of that recovered that way. So so the allocation of the utilities cost to this program is definitely something that has to get figured out. But that all of those things kind of give us an idea as to how much is affordable and how much is practical. But I mean, total cost is one thing, and then cost recovered through base rates is another, and cost recovered through any of the other means, including something like a discount rate, is also part of it. So, all right, so I guess maybe, you know, utilities, if you can begin thinking about ways we can sort of frame this up, at least get some sort of ballpark expected cost, and then, you know, we're probably going to want to plug that into something that allows us to figure out how much can be collected, you know, over the expected time period of the pilot, and what happens if it's not collected, and what happens if it's too expensive and needs to be deferred, or, you know, maybe any number of approaches to it. All right. So let me do this. Are there any other comments or questions before we kind of move down into the third page here regarding cost recovery or any of the other issues? It's sort of a catch-all, and I know a number of folks have raised issues about it.
Phil, I just pulled up the seamless move cost for BGE, and I'm trying to get a refresh, but I think that the estimate was 2.8 million for just BGE.
Okay. 2.8 million.
Yep.
All right. Thank you, Ashish. That's helpful. Laura, you got your hand up.
Yeah, I just want to be sure I'm understanding that there's a proportionality here, or a you know, kind of nexus between costs and the number of customers for that utility. So, you know, there should be analogy here, particularly for Potomac Edison and BG&E that have a relatively small number of Montgomery County customers, that it's analogous to whatever the costs are associated with regular retail supply. So I just kind of want to understand the framing of this, that the costs are proportional to the task and the number of customers.
And I think we need to, when we're, you know, even for BGE and PE, the programming that we need to do to effectuate this, well, maybe there are some things that we can do that are, I don't know what the word, you know, maybe we can, you know, maybe not make it as complicated as PEPCO does, but we're going to have to do a lot of the same programming, whether it's the, you know, 13,000, I think, customers that BG has, or if we had 130,000 customers. So I don't want anyone to think that it's going to be a proportional, oh, you know, BGE's costs are going to be, you know, a tenth or, you know, a whatever of PEPCO's. You know, we're going to have to do probably almost the same programming, if not the same programming that PEPCO will have to do.
So Lori, the type of cost that we're talking about here are not like the cost of mailing to an X amount of customers. We're talking about the cost to make changes to their systems so that they can process the CCA enrollments and unenrollments and notices and all of that. So that's why it's not technically proportional to the amount of customers.
I guess I'm just, you know, maybe I've lost a thread here, that why there isn't sort of parity with change in enrollment for retail choice, existing change in enrollment related to retail choice. I fully understand the PEPCO situation because the volume is so large, but I'm a little lost on why it's so complicated and unique to the CCA when the CCA is following the model of other retail choice suppliers.
So, Lori, if I let me just maybe make a comment on that. One of the things that's very different about the Maryland program is that the CCA is the default supply. I know that when we talked to the folks in Ohio, they used an approach that was much similar to the alternate 3, but you would eventually end up with the CCA if you took no action, but it didn't happen right away. So they were able to use sort of a slower enrollment process that didn't change a lot about the way they built it. Of course, they also had CCAs from the beginning of the retail choice, so that was maybe something that was all wrapped together in the development of that. But what Ashish mentioned, it's the $2.8 million. Imagine that BG&E for 10,000 customers in Montgomery County has to build a system that behaves sort of in the same manner that Pepco's system, which is going to handle 200,000 customers. So it's the system programming costs, and PE I think has 30-some thousand customers. The system programming costs may be identical for each utility if they have to make similar changes to their systems, but if the cost recovery is assumed to be sort of allocated in a way the majority of it comes from the CCA, then you have a very different level of cost, a number of accounts over which to recover those. So I think to some extent we have to understand what the total system cost will be to the utility, and then give them a means by which to recover it. And then the policy decisions are, should that be recovered from the cost causer, but is the cost causer the folks in the county, or is the cost causer the General Assembly for passing the law, or is it something that ultimately will benefit the entire rate base, and so, or perhaps benefit retail choice in some way. So once we know what it's going to cost, or at least have a general feel for it, that may guide some discussions about which of the options we want to select, given that we'll probably at the same time develop some understanding as to how much this will affect the individual accounts participating. Or did that make?
Yeah, no, that was helpful. That was helpful. Thank you.
Right. All right. So I think we're getting close to the end. I don't know how many more issues. There were a lot of folks that were sort of asking questions about this. So let me do this. So just starting with the comments that are added to the document on the side, the utility folks indicated that they had issues with, or sort of recommended avoiding any type of backdating. And by that, what we mean is if someone is enrolling with the utility by moving into the area, so they're starting service, they get put on SOS, which is what happens right now because SOS is the default service. And we don't adopt a method that substitutes the CCA for SOS sort of kind of automatically. We may need to sort of make a backwards adjustment to when that customer began to take service with the CCA, which requires sort of backdating their enrollment. So that's probably a crude way to describe that. But I think what basically saying is the utilities comments indicated that they had a concern about making any changes to the customer's assigned supplier after the fact. So that sort of, and maybe not 100%, that sort of excludes the alternate 2 and 3 to the extent that those options would otherwise, in order to kind of comply with the default requirement, require an adjustment to be made so that sort of reverse an assignment to SOS for a couple of days, until the CCA enrollment could come through. For any of the utility folks, is there anything else about the concern about backdating? I don't know if there's some practical experience you've had with that, or if that's something that had been raised as part of the seamless move discussion.
Well, I think the seamless move instruction, from what I understand from PEPCO, that they have it coded in their system. I would like that seamless move to stay in there the same way it works now without disturbing it. I don't know how to best accomplish that. I would ask for the utilities' help in that, but that program should not be changed, because what it will do is it will delay somebody being able to rent an apartment. We're able to transfer it right to the owner, put it in the owner's name, it goes automatically. And they are able to get in there and paint and clean and get the apartment ready for the next user. If, as in the past, the manager had to go down to PEPCO's office, do a change of account, that delays it by quite a bit. And it also delays it when the customer wants to move in. So however that process works now, I think it should remain the same. And I don't know what process BG&E has, but whatever PEPCO does, it's working. And I don't say that a lot.
Right, Fran, I think we did notice, and you had mentioned like last time, and I think we've learned a little bit more about how that sort of works practically, that there is an arrangement by which when a tenant moves out, that at least in PEPCO, the landlord, if they've just sort of established this relationship ahead of time, does not have to take any further action to put that service back in the landlord's name. And that I guess what you were saying is, when that occurs, if the landlord has contracted with the retail supply, that also automatically occurs. So customer or tenant moves out, and once PEPCO becomes aware of that, the responsibility for the account goes back to the landlord, including the landlord's selection of retail supply, without having an intervening time period where that account is on standard offer service. So I think we've noted that at the bottom of the fourth page is, if there's some existing programs, we want to try not to interfere with those, or noted that your sort of request to make that happen.
Right. And, since the law doesn't really specifically address that, we may need to do that by regulation.
Okay. All right. So just kind of maybe run through the lead option here is just from a practical or for qualitative standpoint. We're just going to mirror what happens with SOS and customer accounts for the purpose of moving in and moving out and transferring service for the CCA. And I think we do not have a conceptual idea of how this would work from a practical standpoint with the utility systems. And so I don't know that is something that staff can kind of develop. So if this is ultimately one of the methods that the working group wants to move forward with, we need the utilities to sort of explain whether or not this can actually happen, such that you can sort of effectively substitute the CCA for standard offer service, for this purpose. But what these first couple of bullets here are attempting to address is essentially describing what happens. The alternative 1 and alternative 3 are a little more along the lines of describing the means by which the compliance with the default service element of the legislation occurs, with the acknowledgement that it doesn't do it as perfectly as one might expect. So that's kind of, let me just sort of, I think we've understood that there are issues relating to how this might work, but I don't know that we have any specifics to why the practical approach of mirroring standard offer service is not a good technical solution, either because it's expensive or because it's not practically possible given the way the systems work. So that, I think we're running with an assumption that no one has raised a particular practical issue with this. So I guess we want to understand if that is a correct assumption or not. The second bullet in this comment is, I think folks were, I think this both this I think the suppliers raised this, and possibly in the utilities comments as well. The way we're thinking about this now is if the customer signs up for new service, they are not given the option on that initial contact to select retail supply or to select SOS. They are informed of where they would go, either to a website or a phone number or what have you, as to where they would be given those options to select one of those, but they would be informed by the utility that they are a Montgomery County customer, and as such, their default service is the CCA, and that's what they're going to be assigned to. Are there any concerns about that process, or is there a discussion on whether or not the utility would be obliged to do anything other than refer a customer that's signing up to either a website or a phone number or some other point of contact to select retail supply? I think maybe the retail, I don't know if the suppliers had this particular concern or if it was something with the utilities and SOS. But I think what we've described here is something where the utility is not obliged to offer a selection when the customer signs up. Is that still a good assumption, or are there folks that would prefer something else occur? I don't see hands, so are there any hands up? I see Leah has gone on video.
It's my visual hand up. I guess from my perspective, Phil, it does, I agree with I think I agree with this red line on here. Because of the way the situation is changing, it does seem like when a customer calls to establish new service and move in, they need to be presented with these options, right? Is that the question you're asking?
So yeah, so in other words, when you call up and say I'm moving in or I have just moved in, and the utility rep responds with, okay, well, you are a Montgomery County customer, so we're assigning you to the CCA. And then, that's either the end of the story, or they say perhaps at least one of two other things. One would be, or you can select one of the following options. That option could be, or you can have SOS, which, whether or not that's fair to retail supply, or you can select retail supply, here are all the offers. Or perhaps alternatively, instead of providing that sort of menu, you say, if you would like to select another supplier, there is a website you can go look at, or here is a phone number you can call, and they will tell you what options are available to you. So that is we're making the assumption that the latter is how the utility will respond. And so there is not a requirement on the utility's part when signing up to present anything other than a reference to where the customer can go learn about choice and what options they have.
I think that makes sense. The bottom line from my perspective is customers, even that are moving in, are supposed to have the opportunity to opt out. So they, at a minimum, they're not getting the notice in the mail, the opt-out notice, but they're sort of getting this verbal opt-out option, right? And I agree that it would probably be the easiest and the best customer experience, honestly, to get them directed to a website or something that has the choices and they can make their choice. Make it easier for the call center agents too, I would imagine, instead of reading some giant script. But I recently moved within Montgomery County, and I went on Pepco's website to do it. And it was pretty straightforward, but there were no indications of, any other options or anything like that. So I think there just need to be some kind of accommodation to at least let the customer know they have the ability to opt out.
Okay. So you're not suggesting, so you're sort of agreeing with the statement that the opt-out process is going to involve the utility referring the customer to some other place rather than presenting a list of things.
I think that's easier. It's easier than worrying about are all of their CSRs going to actually say the right thing? How long does it keep them on the phone? There's just all these other considerations that you have to think about, right? It does seem to me that it's probably easier if the customer was directed to the website. And I mean, frankly, I mean, maybe it's even the utility website where they create a page that's for move-ins, and then that has a link to a landing page where it says, here's your options. You can choose SOS, you can choose a supplier. You know what I mean? To me, it's more about like ease of customer experience.
Okay,
While also giving them their options. So.
Right. I see Lori's hand up. Lori McGilvray.
Yes. Thank you. Maybe just one question. How does it work now when someone moves in from out of state and they want to establish electricity service? They contact their utility and they're placed on SOS. Does the utility at that time refer them to a website where choice is detailed out?
Can I ask one of the utility folks to comment on that?
The answer's no. Answer's no.
So then it really comes down to what is required under the law, which does put it, I mean, it says that, you know, this is not construed to prevent a customer from choosing a third-party supplier or SOS, but that it's actually appears to be a responsibility of the customer to provide written notice to the county declining to participate in the aggregation. So I think it's really, well, what does the law require, where it says under H1, the customer gives written notice to the county declining to participate.
Okay, I think we were also responding to the utilities comments. I think they were asking as to whether or not they should be giving the customers who signs up for new service the option to select SOS or the CCA when they sign up. Is that correct from the utility standpoint? Still have any utility folks?
I mean, I'm here. I'm not a subject matter expert on that, but my read of the legislation is when someone applies applies for new electric service within the territory, they're deemed to be on the community choice aggregator unless they've contracted with a retail electric supplier or they've contacted the utility to be on SOS. So, you know, they may, I think, you know, moving into the territory, the customer says, hey, maybe they already have a contract with a retail supplier. The question, it's like, and they'd want that contract to continue wherever they move. It's clear they're not wanting to be on the CCA there, or they move into the territory. They decide, I don't want to be on the CCA. I want to be on SOS. It's clear they're not in the CCA.
So Taylor, is that means that the utilities really think that the utility should be able to offer SOS as an option when they call to sign up, because I think you're picking up on the part of the legislation that says if they call the utility to select SOS, they get SOS. Is that meaning that you would interpret when they sign up, when they call the utility to apply for service at a new residence, they may simultaneously they should be made available SOS at the time they make that contact, because that counts as the contact?
I mean, that's my read. I mean, I would, you know, if anyone else has a different read, and but my read of the legislation is not that the SOS service is no longer available just because the CCA has been implemented.
So what we're talking about is 7-510.3 G3. And
that's what I'm looking at. Yep.
So G is a residential or small commercial electric customer is deemed to have given permission to the county to act on the customer's behalf as a community choice aggregator. That's the beginning of G. And then you go to 3 and it says, on applying for new electric service within the territory served by the community choice aggregator, unless the customer has I contracted with a retail electricity supplier for service, or I contacted an electric
Company.
Select standard offer service. So upon contacting, you move into a new house, you're going to contact the utility provider. And then if you don't know that those are options, what are you going to do? I think Fran has her hand raised.
Oh, no, I was just going to point to the same section that you just did. If you can proactively select standard offer service, and maybe when you're talking about education materials, that has to be written into the educational materials up front or someplace else. The utility should have on its website, when contracting for new service, these are the options you have, and just state them out. So yeah, I'm pointing to that section. Utility company, I mean, you can at that time when you move in, select standard offer service.
Right.
That
Or
was my
supplier,
point as well.
which is the whole point of the instant connect conversation, right? I mean, that's why I think that specific program is now implicated here, because your customer is allowed to opt out by choosing either SOS or choosing a supplier, which means you must be able to instant connect to them as they're starting new service. But I think, I mean, to Fran's point, and I think everybody's making this point, it's different than today, because today, just by default, customers go on SOS. We don't have instant connect in Maryland today. So it is a change from how things typically work now.
This is Lori. I just wanted to verify that the information available to the customer will not be only about their ability to choose SOS or third-party supply, but information about their default supplier, who is the CCA, because people moving to the area may be unfamiliar with it, and if there is no information about it, then they really are unable to make an informed choice.
Laurie,
I don't disagree.
Yeah, I think that's a good point, but I think you just, by virtue, if they don't say anything though, they just default to the CCA. So I think that's, kind of the catch there that all of us are trying to make.
But just making sure that they are provided information about what their default supplier is, what rate and what it means, so that they're not just, told, well, your default supplier is CCA, you have no information about it, but here's the information about SOS and third party. There should be information about all the choices.
I agree with you, and that's why I was sort of advocating for, not trying to have a utility call center rep take that phone call from a customer and try to say all that stuff, because it'll just take forever, and we're going to have to really worry about scripting that agent. To me, it seems the most efficient way to do it is have the utility direct the customer to a website where they can actually read about the CCA, read about supplier offers, read about SOS, and be able to make an informed choice that way. So I think that to me, one of our goals for the group is, okay, what does that education look like? What does that material look like? And we can all decide and design it, right? And come up with straw proposals of what the website looks like, or possibly a script for the CSR. I mean, I think that's part of what we get to, or we should be helping to figure out.
Just, from a timing perspective, if somebody calls up or they try and sign up through our website, and actually people can sign up, I think, through our mobile app, I'm all for, saying, hey, go look at this website, and it can have information about all customers' options. But, to process that enroll or that, I can't remember what we call that, but to process that sign up at that time, it's gonna have to default at that time to the CCA. It has to do something. It can't wait for the customer to come back and make a choice. So, I think it's, like I said, I'm fine with, having the rep say, or, having the website say, go look at all these options, but it's still going to have to right then, while everything's getting processed, have them default. Otherwise, well, one, I don't know if the system could hold them out of service, but if it did it, it's gonna, possibly not let service get turned on in the first place.
Yeah, I think that makes sense, Beth. I mean, I get that.
Okay.
I think we're all having the same reaction of just having make sure that customers know what their options are, right? Because it's different than it has been.
Is there and let me ask this question, is there something that prohibits the utilities from informing customers that there are retail choice options when they sign up now? Is there, I think the question was asked, when you sign up for new service, does somebody tell you, oh, by the way, there's retail choice in Maryland. Here's a website, go look at that. Is there something that prohibits utilities from doing that? Because that would probably prohibit them from doing something like that for the CCA as well. I'm just wondering, is there a reason that information is not provided when a customer signs up for new service? Does anybody from the utility side know that? Or Leah, do you know?
I don't know that there's a requirement that they do it. I don't think they probably do it. I mean, I just enrolled. I just started new service. I got nothing.
Yeah, I don't, I know when BGE sends out, after a customer signs up, we send letters to customers kind of as, I think we're required to send a letter as kind of a, hey, did you mean to sign up? We may or may not say something in there about, retail choice. I don't think there's anything that prohibits us from saying anything about retail choice that I'm aware of. There's a concern about, we obviously can't favor one or another,
Right.
or not, but I don't think there's anything about, that you can't.
Okay, so just, and that's very helpful. I appreciate that. So, what's being proposed here is option one is that a customer, just dealing with new service circumstances. A customer calls up, says, I'm moving in, or I have moved in, here I am. Is the utility going to be able to assign them to the CCA from day one by a process that, would be internal to the utility? And then the question of whether or not they take a second step and inform customers of other options. It seems like no one is suggesting that they need to tell the customer, you have an option of SOS or the CCA or something else. It sounds like all they have to do is call them up, say, great, you're on service. This is what you're getting. And we can decide whether or not as part of this program, they're going to also give them information about a website or something else. That's probably when we develop the customer education portion of this, and we were talking about the scripts that are going to be used. But other than that, option one, or our initial, or our primary option here is basically treating it just like SOS works. So you sign up and you get a phone, or you call in, or you use the website. You're assigned. I don't know if you're informed of the SOS rates when you sign up now, but maybe if you are, you'll be informed of the CCA rates, and there aren't terms associated with the CCA. It works just like SOS, as far as I can tell from the rest of that legislation. Is there a problem with doing that, I guess, is what I need to understand. If folks have some either objection based on the legislation, or is there a technical issue that needs to be raised that's not a possibility going forward?
This is Valerie with Potomac Edison. If they're going to go straight to the CCA, I think you're going to have some customer questions generated on the back end when they get their bill, if they're not told up front. And whatever that requirement is, I guess will be flushed out here, but it's almost like slamming in a way when they get their bill and it says something other than what they're expecting. I'm not saying it is, but the customer is not going to understand if they're not told.
Okay, so but that would you agree that is something that we can address when we pick up on like the customer education phase of the program design, which probably
yeah, except that I think we're implying it's somebody new moving into the county who might miss out on all that.
Okay, but I guess what I'm trying to understand is, and we can certainly talk about and decide further if the utilities will have, specific requirements to provide, information about alternative supply options at some point during new application. And that might be something that, is less important to the kind of the issue here. But as the way this is going to work, I guess I'm asking, are the utilities going to be able to assign a customer by default to the CCA, which presumably is going to be provided through something very similar to a retail supply contract, based on their existing new application processes and deadlines? So I'm hearing that that's going to be workable.
It's workable if we can get Instant Connect done by then.
Okay, so Instant Connect is our second option, but that my understanding is that is slightly different because it actually would involve a enrollment coming from a retail supplier to a pending account, which is a couple more steps than the way I understand SOS.
Okay, so you're thinking, okay, I guess I didn't understand, like if someone calls up, I was envisioning if I call up and say, hey, I want to be with retail supplier X, right at the time of me me signing up for BGE service, I didn't realize that would still require a supplier to send in a transaction. Yeah, I think we'll have to talk with that's going to have to be a conversation with the IT folks about how, we can have it changed to a default, instead of defaulting to SOS.
Okay.
This is Leah. So I was just to chime in on that one. I mean, I think, that Instant Connect process that Phil just described is basically what the utilities in Pennsylvania do. And so, right, so, I mean, the Instant Connect ones are, if a customer starts new service in BG&E's territory and the CCA is in place and they decide they want to opt out of the CCA by choosing a supplier, they would still, in my mind, have to know who their supplier is going to be, and a supplier would still have to submit the enrollment so that we're kind of following all the same processes that we do today. And then in Pennsylvania, what they do is they just, rather than rejecting that enrollment on a pending account, they just accept it. And then when service starts, they start with a supplier. I think that's basically how it works. I mean, we probably could consider doing it a different way. I think from our perspective, because this law, implicates an Instant Connect by giving customers the ability to opt out of the CCA on day one of service, that's sort of what we were thinking. But there's probably more ways to do it. I think that was just the solution that was adopted in Pennsylvania.
Okay, I didn't realize that it would still have to kind of be that way. Yeah, I think this is going to take additional discussion and our part, because even, I'm thinking, I'm agreeing with folks about too, limiting how much the call center rep has to get into with customers. But if we're going to make them talk about, my first thought was if we're going to have them just defer somebody to a website, it might be easier that any new customer, they send them to some website, regardless of the county where the customer's located, making it easier, because then it's just, well, everybody gets to learn about, retail choice. And, if the customer's in Montgomery County, they can see that, oh, I have this other choice. Having to differentiate customers, that, oh, by the way, you're in Montgomery County, I'm going to send you this website, but know that you get defaulted to the CCA. I just see that like raising questions right away on the call. And then, then we're going to be asking the call center reps to be able to understand it and explain it.
Yeah, I think that's a really good point. I mean, at least in my way of thinking about the Instant Connect piece, because BG&E, Pepco, and Potomac Edison all have customer base in Montgomery County, to me, the thought is, well, an Instant Connect is implemented because a customer needs to be able to opt out of the CCA on day one of establishing service. To me, that just sort of begs for this broader implementation of Instant Connects across the entire utility service territories, because how are you going to limit it to Montgomery County, right? I agree with you. I think that seems like really hard to manage, and why bother? If you've already implemented it for one county, it just can count everywhere, right? So I think I agree with what you're saying.
All right, let me, and I know we're running very close to out of time right now. And some folks have hard stops at right after 4 o'clock. Lori, go ahead. Lori McGilroy.
Well, I just want to be sure that whatever process we use for informing the customer about choice should be comparable for whatever the default supplier is. So if this default supplier is a utility, then they would need to, their call centers would need to notify customers about choice, if in fact that same principle is going to be used for the CCA. Otherwise, the CCA is not de facto the default supplier. They are simply another choice.
Well, except that if they don't make a choice, they're the default.
All right, let me and let me just do this because I want to get through this today. We may need to circle back and continue to discuss some of the technical options here. But let me just do this. These are all very good points. I appreciate everyone bringing them up. From a technical standpoint, and I don't know if the utilities know this yet, but we're going to need you to like take a look at this, and maybe as part of a discussion that staff can have, sort of getting into the weeds on this. It seems that there's definitely issues that folks want to talk about relative to what information is provided to give the customer choice and what information is provided when they're given that choice. And Lori, I think what you're saying is let's make sure that the CCA information is provided if any other information is provided, even though it is the default. But a simpler option is simply to not have that discussion when new application comes along, which is currently, from what I think our conversation said earlier, SOS is simply provided, and then the customer, they're left to their own devices to go find out if there are other options available. So the question our operating premise here for this approach is that we'll simply substitute the retail contract, if that's what it is, from the CCA for SOS. And the customer, is not, if we decide that, the correct thing to do is to refer them somewhere, great. If no information is provided at all, that's consistent with what is provided for SOS. I need to understand if the utilities can actually start a customer on the CCA, when they apply for service. That's kind of, we're operating on the assumption, because no one has said otherwise, that that's a workable option, and the utility systems will be able to do that. So if that is not the case, we're going to need to know very quickly, because that sort of makes it, impossible to do this option.
Well, Phil, anything's possible with the right amount of money. I mean, bluntly, I at some point we could.
Well, no one has said that'll cost $100 million. We can't do it. All I've heard is I don't know that in order to do that, it's any different in terms of scale than some of the other options that are in front of us.
Yeah, and I'll admit I had a mistaken belief that getting the customer on the CCA would be solved by the Instant Connect. I didn't understand what Instant Connect involved. So, and I don't know if others,
okay, well, let's.
So I think we need to talk about that to see what it would take to change.
We may need to sort of delve a little bit further. I think we're touching on lots of policy stuff here, but we will probably need to find out what's practical as well. So maybe what staff will try to do is reach out to the utility folks and ask you to make your technical people available so we can sort of delve into this and make sure we all understand what we're trying to get at. Let me do this. Since we are running short on time, I just want to make sure we've touched. I think we tried to capture what folks' concerns were in some of these comments. So we understand that there's a discussion as to whether or not options are provided for the customer. But I think what we're suggesting here is that if the customer does nothing but call up and say, I'm moving in, they'll just be assigned the CCA and that's it. And we can decide if more information is provided at that time, at that point of contact, or if something else happens. I think the utilities had that question as to whether or not they will be required to offer SOS to a customer who signs up in Montgomery County. And I think that's a policy discussion that we need to sort out. So let's leave that for kind of further figuring out. But I guess technically, does that mean the utility has to be able to make a selection using their computer system when a customer signs up, or over the web when this customer signs up for new service at a location? Or is it simpler just to, have a code that says, well, if you're in Montgomery County, you get assigned not to SOS, but to the CCA, because maybe that optionality has additional costs that we have to be aware of. So that's kind of what we're trying to figure out here. All of this discussion was simply addressing or maybe not simply, but the situation where a customer is moving in to a new residence from outside of Montgomery County or from outside of the service territory. The assumptions for the second bullet here has to do with, this is just, I think what we're trying to capture is something very similar to the way seamless move is expected. So if you are in say, let's say Pepco, and you are moving from within Pepco to another location within Pepco, if you are in Montgomery County and you already have the CCA, is there any reason to expect that that customer, once seamless move has been developed, would have anything other than the CCA at their new location? So seamless move should apply for everything, including the CCA. And if that is not a good assumption, we should understand that. If a customer is moving, the customer is on SOS and they are in Prince George's County in Pepco, and they are moving to a location in Montgomery County, is it a correct assumption that in their new location, when they transfer to that new location, they will be treated as if they have not opted into SOS because they have not actually gone through that process because they were not in Montgomery County? So is there a position, do folks have an opinion on that, or is it accepted that default service when moving within Pepco, for example, or any other utility for that matter, from one county into Montgomery County, you start on the CCA if you are on SOS in your previous location? Is there any, assuming that's technically possible, are there any objections to that? I didn't see that in the comments, but I wanted to make sure we understood. Okay. So that's what our second bullet is, sort of just clarifying what we mean by that. So that if you are moving within the utility and you're moving into Montgomery County, if you have seamless move and you're on retail supply, that you stay on retail supply. But if you're on SOS, you default to the CCA by moving into Montgomery County. All right.
So can I just ask a clarifying question about what you mean? So so you're still within the utility service territory, but you've crossed the county line. That's what you mean, right?
Yes.
For the seamless move thing? Okay.
I mean, that's one permutation of what could happen. I think you just wanted to, I think there was a question about
well,
that.
Because the way, yeah, but I think the way the seamless move rules are designed, it's within a utility service territory. So it doesn't really contemplate a seamless move when you're crossing from BG&E to Pepco, or, you know what I mean? So I was just making sure that's what you meant.
Yeah. I mean, I think what this second bullet here means is an apology for using the abbreviation PG County. I know you're supposed to spell that out. Is that if you have, this is sort of just making this statement as to whether or not folks are, sort of clarify what we mean. If you move into Montgomery County from within Pepco.
Yeah. Okay.
And you're in Prince George's County, you're going to end up on the CCA. If you're in Baltimore Gas and Electric and you move to a location within Montgomery County, but within BG&E, from outside the county, you're going to be on the CCA. Same thing with Potomac Edison. If you
Got it.
stay in Frederick County, you move to Montgomery County. I think we had a question as to clarify that. So that statement's just saying, yeah, that's what's going to happen. If folks disagree with that, we should understand that. So. All right. So there are maybe four other issues here within our first one. So dropping from SOS, and I think what we were trying to do is there are a couple different ways that you might kind of want to, after the transition, then you could end up with the CCA. So if you drop SOS, you would be doing that by contacting your utility saying, I want to drop from SOS. Why would someone know to do that? I don't know. But if they did call up and say, I don't like SOS, the utility is going to put them on the CCA because that's the new default service in Montgomery County. That's just mirroring what happens if you drop from any retail supply source now. I don't know that the customer is actually going to know that they could do that or that, but just to clarify that if they actually call the utility and want to drop SOS, maybe they are upset with the increase in the price or the change in the seasonal price, they're going to end up on the CCA. If you drop from retail choice, okay, so if you are essentially following the rule that you call your retail supplier and you tell them to drop you, they should just drop you and then you end up on the CCA if you're in Montgomery County. If for some reason that process fails, then you follow the other rule that says if you've, I guess if you confirm with the utility that you've called your supplier 3 days before and it didn't happen yet, they can drop you. But then in this case, they will drop you not to SOS. They will drop you to the CCA. This may also develop a question as to whether or not they're going to tell you, would you like to be dropped to the CCA or dropped to the SOS? But that's similar to the move-in question that we can probably solve. Again, no one has said that they have an issue with this, but I think we wanted to try to clarify a couple more of these. This one I think is new because we looked at it and we maybe missed this particular permutation. After the transition has occurred, so you may be on SOS or you may be on retail choice. We thought it's probably likely if someone is going to switch to the CCA, say maybe because they find out they like the price or they don't like the retail choice contract, one of the ways they can do that is they can just contact the county, the CCA, or maybe the supplier of the CCA, and they can just request an enrollment like anyone else would select a retail choice contract. So that's another way that could happen. And that would be a situation where the customer is, it is December of 2024, the customer is on SOS because they got that notice and opted out of it for some reason, but then they changed their mind. How do they get on the CCA after they've already opted out? They have to contact the CCA to enroll, and they'll, just like any other retail supplier. I think we had not made that clear. The last one was an automatic drop from the end of contract and assigned to the CCA. I guess we're expecting that this is going to work no different than a regular retail contract would now. I don't know how many contracts actually drop you at the end of your contract. I think a lot of retail choice contracts, especially for residential customers, simply put you on a variable rate that moves up and down that you may or may not, be able to find out the price unless you call or something. So I don't know that there are many contracts that automatically drop you. If there is one, that drop is going to put you on the utility will assign you to the CCA. So I guess, whatever logic has to be developed, the utility has to know that anytime a drop transaction is received where the retail supplier is dropping the customer, the utility is just going to put a Montgomery County customer on it on CCA, not SOS. And I think Lori McGilvray had in her email a question about notification, so that if a customer, and Lori, if you're still on the call, maybe you want to just tell us what you meant here, but I think what you were asking is if your retail contract ends and you get dropped by your retail supplier, because that's what happens in your contract, are you going to find out that you've been switched to the CCA? And I think maybe what we know is that anytime you move to a retail contract, you're going to get a letter, but maybe the utility folks can respond to that. And let me ask Lori, did that capture what your question was?
Yeah, I mean, just because there's sort of transparency and notification in the law, it seems that something should happen if you are unaware that these things are transpiring, like your retail contract ends, and right now you would kind of learn after the fact that you switched over to SOS. I don't know how you are told that happens now, but a similar thing should happen, that you are notified that you have been dropped from your retail supplier and have been picked up with the CCA. So it's really just a notification thing. I think what one of the utilities said is that there's a letter that goes out when you are placed on SOS. So is there a comparable letter that ought to go out when you are placed on CCA?
Okay. Well, so I think what we heard is that anytime you switch to a retail supply contract, and since this is going, the CCA is going to act like one, whether or not actually is from a retail supplier, you're going to get that letter. So I think we are normally providing that, so we would have to do something different to change it. But when we examine, I guess maybe the switching rules to see what we need to change for this, there's a requirement, I think, in there possibly to send that letter. So we'll have an opportunity to take a look at this, but it seems like it's already happening automatically under the existing system.
And this is Robbie for PHI. When they issue, if the supplier drops the customer, or if the customer drops the supplier, we issue a drop letter to the customer advising them of the selection or advising them of what happened to the account.
Potomac Edison does as well.
Okay, so
I don't know if that's a requirement. I quickly went through Comar and I didn't see that as a requirement. So that may be something that we want to earmark for making that type of communication a requirement.
you mean the judge? You mean the notice?
Yeah.
Okay. Yeah, my recollection is that there's something in there that says that a letter goes out, but it's been a while. So
If somebody sees that, please let everyone know. Because it was just a really quick flip through, but I didn't see it, and it seems like, notice would be great. So I'm glad.
I think that's why they do it. Like,
yeah, I'm glad the utilities are doing it, but I just if it's not a requirement, it's maybe something we want to revisit.
Sure. I'll try to make a note to find that. All right. So let me do this. So the only major comments I think we had on alternate 2 and 3 had to do with there is a 2 and 3 both are not like a default switch to SOS now. They both involve possibly a temporary assignment to SOS while enrollment comes through, or while you wait for a weekly sweep. So alternate 2 is using Instant Connect, and Instant Connect, as I sort of described it a little bit earlier, and Lee, I think you are correct in that this is an approach used in Pennsylvania, but I think it was also what had been proposed when Joey Chen's group had looked at this a couple of years back. Well, actually, it wasn't Joey's group at the time, but so
Right.
Instant Connect is a means by which the utility is going to accept a transaction for enrollment for an account that is not yet active. So they create the ability to establish a pending account and keep that in their database somehow. And if an enrollment comes in, that pending account has a different number than the active account. So the enrollment comes into this pending account, and again, I guess currently, if you try to enroll a pending account, it gets rejected. But they're going to accept that under if Instant Connect were to work. So what we'd be doing here, the side benefit is possibly that Instant Connect then becomes available for all of retail choice throughout the 3 utilities that are involved here, maybe even some of the other ones. But the problem is that Instant Connect might require some other changes because an enrollment might have to be sent by the CCA, and that could be an issue. It may have a certain amount of time in advance that has to be provided in order to allow various transactions to go back and forth. So possibly Instant Connect is something that can be done slightly differently than the way it would work for like retail choice proposals for Instant Connect. But in order to sort of solve any delay problems and still comply with the default issue, one possibility was backdating of that enrollment, which we understand the utilities have some concerns with. So no one really talked a lot about these, I don't believe, other than to note that there were some technical issues with them. But I think just if to the extent that any other alternatives, this one in particular is at least has some development history, as mentioned in other jurisdictions, and also has been sort of considered a little bit here in Maryland, if not in depth. My understanding is there's also some similarities between Instant Connect and the way Seamless Move is being proposed to work in in Joey Chen's working group, in the CMCC working group. So possibly there is some cost savings from concurrent development or piggybacking on some of those processes. Again, that's something that we don't know a lot about, and I don't think we asked those specific questions. So this is an alternative. I think it has concerns in that it doesn't sort of mimic SOS the same way the first recommendation does. The third alternate, I apologize, it's on 2 different pages here, so I don't know if I can catch it all. But this is a model that's similar to what we understand is used in Ohio, for example, where enrollments are gathered up over some period of time and then sent to the CCA to add those customers at a periodic amount. Again, Ohio does not have the default requirement for their CCA. It's more optional. Although I think what happens is if you take no action, you end up on the CCA. It just takes, in their case, a full quarter, I think, before that happens. There are benefits to the CCA in order to control the amount of load they have to deal with every day. So there's some benefits there. But again, there are delays, and we would have to decide if this ended up being something that was considered, decide whether or not there are any issues with compliance with default sort of interpretation of how default supplies is going to be kind of worked out. All right, so let me just sort of jump down here. We had this last page. I don't want to delve too much into it just because we don't have a lot of time, but we will definitely want to ask the utilities a little bit more about what happens. Fran, we picked up on the AOBA request about not interfering with the way your existing sort of landlord-tenant program works. So, to the extent this is where we sort of made a note of it in our document. So it is being picked up, and we'll try to figure out if that's going to be something that works or if there's other problems with it. So opting out of the CCA post-transition, I think this is something that we were trying to pick up. Whether somebody had a question about, I forget which entity, but if the CCA doesn't drop a customer, I think we're going to, like, the customer somehow wants to drop to SOS. The first way they're going to do that is contacting the CCA. That would be normal because that's how retail supply contracts work, and there would be no difference in that process if we're going to follow kind of using existing enrollment processes. So I forget who had the question about what happens if the customer wants to get out of the CCA. They could do that with the utility, but I think the preferred method would they first reach out to the CCA and say drop me, and then the utility would have to know that when they get a drop from the default supply, that means it goes to SOS. And does that extra logic, or is that a problem? So,
Bill, you keep saying call the CCA. Wouldn't they call the third-party supplier to do it versus the CCA?
Well, I'm using that. I'm not making the assumption that the CCA is going to use a third-party supplier yet.
Okay.
I know that is a very considerable decision that has to be figured out, but I say CCA, if they are using a default supplier and that's who the CCA wants them to contact, then they'll use the TPS.
Okay.
But if it's not it's not like one of our named licensed retail suppliers that they're reaching out to, then it might be something else.
Okay.
But, I think this was just something that folks asked, well, how do you drop we don't really want the customer to first call the utility and the utility have to say, oh, okay, well, we'll drop you to SOS. I think we want them to contact the CCA, request return to SOS. Then you have to, the utility needs a way to recognize that, oh, I just got a drop from the CCA's supplier, in this case, their default supply. So whatever logic I have that up for any other retail supplier would drop me to the CCA would have to drop them to SOS instead. So obviously they could switch away from the CCA by just signing up with a retail supplier as well, but that logic I don't think we have to worry about. This may be more of a clarification than anything else. And I think we clarified that the way the drop cancellation worked when we were talking about that earlier previously. So the last one there is, I was just making a sort of a running list of things we will need to deal with in terms of regulations. So as we delve into this a little bit further, this will become a separate document, and as once we identify all the changes we're going to need to make into the retail choice regulations. But I think in particular, this one was responding to AOBA's request that any information provided, and I guess AOBA would like us to simply avoid providing any of their customers' information to the CCA by opting out first, but any information provided to the CCA would have to have at least some regulatory requirements for confidentiality. How one physically assures that might be a different story. So, and I apologize for running so much over. Judge Grace, that's all we had. I think what our next game plan will do is, so our next meeting, I believe, is the 15th of March. I think we're going to probably have to turn around and revisit some of the enrollment issues. So the next week, the staff is going to try to reach out and talk to the utility folks and really dive into the technical details, in particular on option 1, so that we can figure out a way to make the transition or the transition to the CCA function in a default method that sort of mirrors how it works in SOS. So the utility folks will try and schedule something with you next week to do that. And then when we meet next time, hopefully we'll have some more answers about that, and maybe even some information about cost. And then what we sort of need to think about, maybe from the folks in the county, is if you know, where are your concerns about the amount of cost that ultimately might be imposed on Montgomery County customers in order to implement this program. And then we will, I don't think we'll have a new agenda for the 15th other than to come back and circle around for these things. But I think our next move is going to be to identify the regulations we're going to have to change in order to make this work. And then also get a plan together for developing and approving the application process for the CCA. So those, I'm not sure which of those will be faster in terms of what we approach next, but I think that's where we're going to go.
Hey, Phil, real fast. I think you asked for the cost for PHI for seamless moves.
Yes.
It's 2.8.
That's the same as BG&E's.
Correct. Yeah.
We get 2 for 1 there, or is that what is that 2.8 for each?
For each.
Okay. Okay, sounds good.
Phil, I think I kind of tried to tick it off as we were going, and I think that these redlined straw man have identified all of the issues that have been raised by the other parties. But to the extent that there are further questions, or you feel like your issue hasn't been sufficiently addressed, if you could circulate an email to everyone so that we know whether or not what we've looked at so far is, you know, a general consensus, or if there are still issues remaining. And do we still have the folks from AOBA on? If you want to further, you know, like describe if there's anything further that AOBA needs to describe regarding its 2 proposals, and circulate that, that'd be fine too. But I just, and then if there's any more comments on options 2 or 3 from staff, please just send those around in writing in the next week so that we can all see the specifics of what the questions or objections are and respond to them accordingly. That would be great.
Judge Grace, I think what we'll do is I'll send an email out. I think we'll ask folks to get us, further responses by the 9th. That's like next Wednesday. And then we'll try to schedule the meetings with the utilities. We may have to kind of delve a little bit further into some of the technical issues to see which of these options. I mean, I think what we've heard so far is no one's raised the technical issue with simply mimicking SOS. But once we talk to the utilities of how that might actually be implemented, we'll know if we have to, deal with one of the other options first because of cost or some technical problem we can't overcome. So we'll get an email out to try to be more clear about what we need folks to provide some information on, and we'll set those meetings up. And to the extent anything else pops up, we'll just, we'll use the email list.
Sounds good. Okay, does anybody else have anything we need to talk about today? I sent earlier while we were on this call out an invitation for the next meeting on Zoom. So if you didn't receive something, please just send me an email separately, and I'll make sure that you get that. If not, thank you, everyone. It's 4:20. We had a long day, but I feel like we got a lot done, so thank you.
Everybody have a great one.
Thank you.